Good afternoon, members. Myself, CA Chawla, welcome you all in this today webinar on succession planning and inherent law. Today, we are very honored to have very senior chartered accountant CA Vinod Jain ji as guest speaker, as well as advocate Ananya Madhusudan and advocate Akhilesh ji will be taking this session, and we will discussion on basics of law, money, and control driving succession planning. Number two, discussion on execution of a will as well as important tools. Number three, discussion on succession law for Hindus and others. Number four, discussion on succession of large and mid-sized family run business and succession of professional CAs in practice. Also, we are honored to have our session chairman, CA Advocate Asim Chawla ji. Welcome, sir.
Thank
Our
you.
guru of this webathon series. I also welcome CA Sunil Garji, my friend and moderator of this webinar series. I also welcome CA Amit Agarwal ji, past chairman, Mathura branch, and today guest of honor. Welcome, sir.
Sir,
I am also pleased to announce upcoming release of Supreme Court of Company Law Compendium of Cases 1950 to 2021 in 3 volumes created by C.A. Asim Chawla ji, published jointly by Bloomberry and Corporate Law Advisor. The compendium puts all together all the significant judgments rendered by the Supreme Court on matters arising under the Companies Act 1913, 1956 and 2013, covering judgment from 1950 till 2021. Each judgment has been supplemented with a precise head note highlighting the radio dedicated by the Apex Court. Relevant parts to the judgment have been mentioned for quick reference of the ratio. Besides nominal index, the compendium has been enriched with the comprehensive subject index, which has been drafted in a lucid manner, adding to the utilitarian potential of the publication along with the section in box. So, with this, now I request our moderator, CA Sunil Gargi, to please start this webinar.
Thank you, Rajji. I welcome our guest of honor today, CA Amit Agarwal ji from Mathura. He is the past chairman of Mathura branch.
Namaskar, sir.
I welcome and congratulate our session chairman and our course moderator, Sri Asim Chawla ji, for his new launch and his earlier book also, Twist and Turns, a very successful book. Everybody should read it. I am reading it these days. I also waiting to Shri Vinod Jain ji, very senior member, who will be taking session on this succession planning, wills, gifts, HUF, business restructuring. All these topics will be taken by him and his team. And friends, this is 2 consecutive webinars we are doing on this topic. One today and another on next week on 12th March. And if time permits, and if the course is not completed, if the subject is not completed, then we can have a third webinar on 19th March also on this topic. It is up to Shri Vinod Jain and his team whether to complete in 2 webinars or 3 webinars. Now coming to today's topic, friends, this topic of succession planning has taken a very important role these days. What is the difference between wills, gifts, what act will be applicable, Hindu Succession Act क्या कहता है, what is the applicability of Hindu Succession Act, and what are the tax laws, section 159 to 178, specifically dealing with 159 to 168, dealing with these successions, what are the provisions. और मैं एक लाइव एग्जांपल असीम भाई देना चाहूंगा इसमें, जो मेरे साथ हुआ, मेरे क्लाइंट के साथ हुआ. और ये जो यंगस्टर्स हैं जो प्रैक्टिस में आ रहे हैं, मैं कह रहा हूँ ये इतना बड़ा फील्ड है, इतना बड़ा टॉपिक है कि आप सबको इस पे मास्टरी करनी चाहिए. यू शुड डेवलप ए स्किल इन दैट. देखिए क्या हुआ, और ये शायद एक केस स्टडी भी होगा, इस पूरे 2-3 वेबिनार्स में आप सीखेंगे. मेरे क्लाइंट ही वॉज क्वाइट यंग, 45 ईयर्स की एज उसकी थी. ऑल ऑफ ए सडन 2-3 years ago in 2020 he died of a heart attack. मॉर्निंग में अटैक आया एंड ही डाइड. अब उसकी फैमिली का जो स्ट्रक्चर था असीम जी, वो उसकी वाइफ, 2 माइनर बच्चे, और वो उसके पेरेंट्स जो रहते थे वो उसके ब्रदर्स के साथ रहते थे, वो अलग रहता था. हम सोचते हैं कि भाई डेथ हो गई, चलो अब जो भगवान ने किया. लेकिन अब सक्सेशन में देखिए कितनी दिक्कत आई. आदमी सोचता है कि मैं, मेरे बाद मेरी बीवी और मेरे बच्चे. लेकिन नहीं सर, हिंदू सक्सेशन एक्ट में क्या है कि इफ ए मैन डाइज,
नजर ही नहीं आ रहा था इंटर स्टूडियो.
सर नमस्कार, आई वेलकम आवर गेस्ट स्पीकर टुडे श्री
नमस्कार, सर.
विनोद जैन. सर थैंक यू एंड वेलकम सर. तो सर मैं एक लाइव का एग्जांपल दे रहा था सक्सेशन प्लानिंग को लेके कि मेरे डेथ की एज, मेरे क्लाइंट की डेथ हो गई 45 की एज में.
हेलो सर, कैन यू हियर मी? आई एम नॉट एबल टू हियर यू सुनील भाई.
आपको मेरी आवाज नहीं आ रही सर?
हेलो.
हाँ.
यस यस, नाउ द वॉइस इज कमिंग. यस.
ओके सर, थैंक यू.
कैन यू हियर मी?
हाँ, यस सर, यस सर, यस सर.
जी जी.
तो मैं सर थोड़ा एक ना केस स्टडी बता रहा था कि हाउ दिस सक्सेशन प्लानिंग वर्क्स. जैसे मैंने कहा कि उनकी डेथ हो गई और उनकी वाइफ, 2 माइनर बच्चे, और उनके पेरेंट्स उनसे अलग रहते थे. अब हुआ क्या कि हिंदू सक्सेशन एक्ट में, क्योंकि विल नहीं थी, इंटरस्टेट डेथ थी, तो आपको पता होगा हिंदू सक्सेशन एक्ट में मदर, वाइफ और चिल्ड्रंस का इक्वल शेयर हो जाता है, जो क्लास 1 हीयर होते हैं. अब हुआ क्या कि उसकी डेथ के बाद में, क्योंकि शेयर उसकी मदर को भी जाना था, अब तो उसकी मदर उसके पास रहती नहीं थी. अब मदर के पास भी राइट है कि जो उसको शेयर आएगा वो किसी को भी ट्रांसफर कर दे. और सेकंड इशू क्या आ गया, क्योंकि उसके बच्चे माइनर थे अभी. अब माइनर इंटरेस्ट आने के बाद में प्रॉपर्टी में और लोचा हो गया, क्योंकि अगर प्रॉपर्टी में माइनर इंटरेस्ट आ जाता है तो यू कैन नॉट सेल द प्रॉपर्टी विदाउट द परमिशन ऑफ द कोर्ट. सेकंड इशू था कि उसके पास रेंटल इनकम भी थी, और रेंटल इनकम में भी जो टेनेंट्स थे उन्होंने कहा जी अब माइनर इंटरेस्ट आ गया तो आप वो भी सारे चेंज करवाइए. मेरे कहने का मतलब ये है कि आपकी अगर इंटरस्टेट डेथ है तो आपकी सक्सेशन जो होगी हिंदू सक्सेशन एक्ट के हिसाब से होगी. तो एक इशू तो ये. दूसरा इशू बहुत सारे लोग पूछते हैं जैन साहब, दैट इज अबाउट द गिफ्ट एंड द विल. तो फ्रेंड्स, गिफ्ट जो है वो आप अपने जीते जी कर देते हैं और इरिवोकेबल होता है. वंस यू हैव गिफ्टेड द प्रॉपर्टी, इट इज इरिवोकेबल. यू कैन नॉट टेक बैक द गिफ्ट इन एनी कंडीशन, व्हाइल यू कैन चेंज द विल एनी टाइम. एक इशू हमेशा ये रहता है. दूसरा, अगर आपने विल में किसी को एग्जीक्यूटर बना दिया तो सेक्शन 168 को भी ध्यान रखना है कि उसकी जो असेसमेंट होगी उस टाइम में जब टैक्स लायबिलिटी आती है. तीसरा सवाल आता है लेके प्राइवेट ट्रस्ट को. प्राइवेट ट्रस्ट इंटरव्यू हो सकते हैं. ड्यूरिंग योर लाइफ टाइम यू कैन सेट ए प्राइवेट ट्रस्ट. आप डिस्क्रिशनरी ट्रस्ट बना सकते हैं, आप स्पेसिफिक ट्रस्ट बना सकते हैं. अगर आपने स्पेसिफिक ट्रस्ट बनाया तो टैक्स सेक्शन जो है 161A कैपिटल ए के हिसाब से आपको टैक्स लायबिलिटी होगी. अदरवाइज 164 में आप चले जाएंगे. और दूसरे सक्सेशन प्लानिंग को लेके बिजनेस रिस्ट्रक्चरिंग के इश्यूज हैं. तो हमारे साथ में वी आर वेरी ऑनर्ड टू हैव द टीम ऑफ श्री विनोद जैन जी. एंड एज आई सेड in the beginning, sir, we have reserved 2 days for this webinar, today and on 12th, and we have kept a spare day on 19th March also. अगर 2 वेबिनार में ये नहीं होता सर तो हम चाहेंगे कि आप अपना टाइम लीजिए, आपकी टीम पूरा टाइम ले और हम एक वेबिनार इस पे और भी कर सकते हैं. तो विद दीज वर्ड्स आई वेलकम द टीम ऑफ श्री विनोद जैन जी. एंड मैंने सुना है सर का NIRC में किया था आपने, आपकी टीम ने. दैट वाज वेरी एक्सीलेंट. Now I request Mavia to carry forward this webinar. Over to Mavia.
Thank you, Sunil sir. Now we are very honored to have CA Amit Agarwal ji as a guest of honor of today's webinar. CA Amit Agarwal ji is a practicing fellow chartered accountant practicing since 2006 in Mathura. He has vast experience and expertise of practicing in the field of direct and indirect taxation and specialized knowledge in the field of charitable trust and institution. He also shared his professional knowledge through videos on his YouTube channel. He also had served as a chairman of Mathura branch of CIRC of ICI. He also had engaged as a member and office bearer of various social and religious organizations and is currently working with organization named Pratham Pehal Foundation, which is engaged in organizing free vaccination camps and free healthcare facilities to all. I welcome you, sir, and request you to say a few words on the topic. Sir, your mic is mute.
आप सभी को नमस्कार, राधे राधे, जय श्री कृष्णा। आज का आवाज आ रही है मेरी सर? सर मेरी आवाज आ रही है?
Yes, sir.
आ रही है अमित भाई, आ रही है।
सर सबसे पहले तो मैं आपका धन्यवाद देना चाहता हूँ, स्पेशली सुनील गर्ग जी का, कि आज आपने मेरे को इतने बड़े प्लेटफॉर्म पे आने का मौका दिया और आज आपने इस प्रोग्राम के लिए गेस्ट ऑफ ऑनर मेरे को बनाया। आज का आपने जो टॉपिक चूज किया है, सक्सेशन प्लानिंग। सर आज के परिवेश में जो हम लोग कोरोना काल में रह रहे हैं, अभी कोरोना से हम थोड़ा सा उभरे हैं, तो आज के परिवेश में जो सक्सेशन प्लानिंग का टॉपिक आपने लिया है, ये टॉपिक बहुत ज्यादा हॉट है। आज कहीं ना कहीं देखी जाए तो हम सभी लोगों को इस चीज की जरूरत है कि हमारे बाद हमारी फैमिली का क्या होगा। हम सभी लोग इस समय पैसा कमाने में इस कदर व्यस्त हो गए हैं कि हम किसी भी प्रकार की प्लानिंग नहीं कर पाते हैं। ना ही हम अपने किसी क्लाइंट को इस प्रकार की प्लानिंग की कोई एडवाइस कर पाते हैं। तो आज का आपने जो टॉपिक लिया है सक्सेशन प्लानिंग का, इसमें हम आज ये देखेंगे कि हमको विल कब बनानी चाहिए, और अगर हमारी बिल बन जाती है तो विल बीच में हमको चेंज हो सकती है या नहीं हो सकती है। और जैसे अभी अपना सुनील गर्ग जी आपने बताया कि अगर कोई व्यक्ति गिफ्ट कर देता है तो अपने लाइफ टाइम में गिफ्ट को फिर चेंज नहीं कर सकता है। तो इन्हीं सारी बातों को आज हम हमारे एक्सपर्ट सीए विनोद जैन जी, जो कि इंडिया फेम है, आज हम सक्सेशन प्लानिंग के बारे में उनसे बहुत सारी चीजों को समझेंगे और अपने अंदर जो इस तरीके की हमारी भावना है कि सक्सेशन प्लानिंग किस प्रकार से हो, इससे कि आने वाला जो समय है, अब जो हम इस समय पेंडेमिक में जी रहे हैं, आने वाला समय भी कोई बहुत अच्छा नहीं है ऐसा हमको लगता है, क्योंकि कोरोना की वेव बार बार आ रही है। तो सक्सेशन प्लानिंग के लिए आज हम विनोद जैन सर को समझेंगे और ये जानने का प्रयास करेंगे कि हम उसको किस तरीके से प्लानिंग कर सकें। धन्यवाद।
Thank you, Amit ji, for your kind words.
Before Mavia, 1 minute please, let me chip in. A very important question has come from the viewers और मैं चाहूंगा विनोद जैन साहब जब इस पे बात करें तो इसको जरूर लें। एक लोगों को बड़ी खुशफहमी या गलतफहमी है कि HUF की कभी जब डेथ होती है तो वो जो प्रॉपर्टी है HUF में ट्रांसफर होती है। आपके फादर की डेथ हुई तो आपको जो प्रॉपर्टी मिलेगी वो HUF में आएगी, ऐसा नहीं है मेरे हिसाब से। अगर उनकी डेथ होती है इन द स्टेट तो आपको हिंदू सक्सेशन एक्ट में जो प्रॉपर्टी आती है वो इंडिविजुअल हाथ में ही आती है। HUF की प्रॉपर्टी तभी आती है जब उनकी HUF से आए, इफ आई एम नॉट रॉन्ग। तो मैं चाहूंगा सर जब आप इसको लें तो HUF पर एक सेक्शन जरूर लें कि कब प्रॉपर्टी HUF के हाथ में आती है और कब प्रॉपर्टी इंडिविजुअल हाथ में आती है। और दूसरा जो 2005 में कहा था डॉटर्स और डॉटर्स को HUF में को पार्टनर है, वो भी HUF प्रॉपर्टी के लिए है। अदरवाइज हिंदू सक्सेशन एक्ट में तो डॉटर्स को इक्वल राइट पहले भी था, आज भी है, 2005 में कोई चेंज नहीं हुआ है मेरे हिसाब से। ये दो बड़े इंपॉर्टेंट मेरे पास इनपुट्स थे। तो नाउ ओवर टू मावी अगेन।
Thank you, sir. Now we are very honored to have Advocate Asim Chawla ji as a session chairman. Asim ji is the practice leader at ASC Legal Solicitors and Advocate in New Delhi. Asim ji is a member of Bar Council of India and fellow chartered accountant and certificate holder of comparative tax policy and administration from Harvard Kennedy School. Asim ji has extensive experience in advising on variety of tax matters, including international tax, inbound and outbound investment structuring, cross-border tax issues, etc. I welcome you, sir, and request you say a few words on the topic.
Thank you, Mavia, for your diligent coordination all along for all these months and making sure that you keep us honest on our toes. My gratitude to our dynamic council member Rajji for leading from the front and making us and coming up with these very interesting ideas all along in the cause of profession. Sunilji, as always, you are the bedrock of Webathon, and now it is in its second avatar, Webathon 2.0. I'm equally grateful to all the warm wishes which we get from the holy land of Mathura, Mr. Amit Agarwal, and thank you for his gracious presence. Needless to say, we will be very enriched today. We have a very eminent faculty comprising Team INMAX led from the front by very erudite and very well-known captain of the accountancy profession, Jain Saab, Mr. Vinod Jain and his team bring a lot of value in various multidisciplinary skills, not only for the clients, but importantly for the profession. I mean, in my formative days, I still remember the print newsletter which Mr. Jain's office very regularly used to send to all the members, and it was something which all of us used to read very regularly. So, and the sheer fact that consistently over the last almost 2 decades or even more, the way he's contributed to the cause of profession speaks volumes of the fact that he is holding and has held positions which are very elusive for any profession in his career. Garg Saab, you've raised very important points, and I think the good justice will be done by this very erudite team led by Jain Saab. As a member of Society of Trust and Estate Practitioner, STEP UK, where this is the subject matter which we are taught, that how to help families in terms of wills, etc. And STEP is very popular all across the world, and it's a great honor to be a STEP member from India. And over the last few years, as part of our private client experience, I think few aspects which I can certainly speak on a first-hand professional practice basis. जो हाथ से काम निकाला है जैन साहब उसमें तो और गर्ग साहब उसमें तो जो लर्निंग सीखने को मिली, जैसे हिंदू लॉ की आपने गर्ग साहब बात करी, तो एक हमारे को एक ओपिनियन देने का सौभाग्य हुआ कि क्या हिंदू लॉ की एक्स्ट्रा टेरिटोरियलिटी है. अभी आप एक फैमिली अरेंजमेंट कर रहे हैं अंडर हिंदू लॉ. फैमिली अरेंजमेंट इज नॉट अ कोडिफाइड, it's not codified per se. It's a judge-made law, and you have the famous classicus decision of Kale, which I'm sure Jain Saab's team would enlighten, and several iterations of of Kale's decision, and therefore we had to opine on the fact that if there's a family which by faith is Hindu and nothing is in India, still can they invoke the tenets or canons of Hindu law? And I remember doing that opinion sometimes in 2015, 2016, which went to a QC in London for his view, and then to their chartered accountants in UK. Uh, and and then I realized that there was some bit of jurisprudence also, because there are certain common law countries still which follow the common British law, so to speak, that in some old families which were, Indians by faith, in Kenya, had these issues arising, and you had some jurisprudence which we found under common law, where we found some court decisions on this. So that's one aspect. Then with listed companies and too much of wealth consolidation happening on private trust side, which is a convenient tool, and there are specific dispensations even from takeover code, which Jain Saab I know deals very regularly in advising all blue chip families of country, and how SEST regulations do allow exemptions from in such situations. That also you could ask for a non NAL or something like a ruling from the SEBI to the extent where transfers are inter vivos within family. So that is the SEBI bit. FEMA bit is also with non-resident families and a lot of expatriation happening courtesy IT and other movable high net worth individuals, and the fact that now you have the third generation coming into being. If you look at 70 years of India's independence, and there is a fair bit of Indian diaspora happening. So how under FEMA you would consider these aspects, especially in trust structures? Would you look at the residential status of trustee? residential status of beneficiary, settlor, kinds of asset settled, location of asset, distribution mechanism. क्योंकि गर्ग साहब ये थोड़ा सा ट्रिकी है, अभी हमारे ऊपर एक वो ब्लैक मनी एक्ट भी है ना, तो उसके डिस्क्लोजर्स कैसे हैं, आप उसको कैसा स्वरूप देखते हैं, सो वो एक टिपिकल अनयूजुअल सा एंगल है. सक्सेशन की आपने बात करी, क्लास 1 हियर, देन सुप्रीम कोर्ट क्लैरिफाइंग वेरी रिसेंटली अबाउट द amendment in the Hindu laws with regard to the co-pasni rights of daughters. You had two conflicting decisions of Supreme Court, and the larger bench sat on it. But not very many of us, and I'm telling you with all humility, would have read that, look for wills, please go to Indian Succession Act, don't read Hindu law.
Yeah.
Hindu Succession Act is not going to help you. It's going to help you in interstate succession. And to draft a will, I'm telling you, the canons and the principles of Indian Succession Act eventually help on lot of things. Of course, I could write a will even on a, जैसे हम समझते हैं और होता भी है कि एक दिन शाम को बैठे बैठे एहसास हुआ, आपने प्लेन पेपर लिया और उस पर कुछ लिख दिया. अब वो लेटर ऑफ विशेज है, विल है, लिविंग विल है, उसका अपना स्वरूप है. You don't need a sophisticated chartered accountant or a very intelligent personal lawyer to help you on drafting a will. मन में आया, आपने लिख दिया. बट अगर आपको इंडियन सक्सेशन एक्ट का संज्ञान है और उसके बाद आप अगर क्लाइंट को, फैमिली मेंबर्स को विल से रिलेटेड उसके पहलू को समझाने की कोशिश करते हैं, तो बहुत उसमें वैल्यू निकल के आती है. तो उसमें भी आई थिंक देयर इज दैट fair bit of dimension which we need to look at. And then there are a lot of familial consideration. Advising on such matters requires understanding of, as I say, drawing room, boardroom, and eventually bedroom also, in all positive sense, because these are very intimate issues which you are discussing. अभी आपने जैसे एग्जांपल गर्ग साहब दिया वो माइनर का, फैमिली का, and when you are looking family businesses, you will be surprised in GDP. हम सोचते हैं फैमिली बिजनेस इज pretty much an Indian concept. नहीं, large families, large businesses globally are family owned business, be it Coca-Cola, be it Walmart, be it Renault. And family businesses contribute, at least in the Indian context, about 70% of India's GDP, which is not a small number. But the challenge with family business is that only 12% of family businesses make it to the third generation. सिर्फ 12% business है जो तीसरी generation तक survive करता है, and only as low as 3% gets passed on to the fourth generation. So I think the biggest challenge for a successful business, which is an evergreen business, is to be able to see how do you perpetuate the business. फैमिली बिजनेसेस फेल उन, किसी ने बड़ी अच्छी बात कही कि फैमिली बिजनेस पे फेल क्यों होते हैं, तो उसका जवाब भी बड़ा खूबसूरत था, दैट फैमिली बिजनेसेस जनरली फेल फॉर फैमिली रीजंस ओनली. So these are things which I'm sure Jain Saab brings a lot of value and experience onto the table. Things like continuity planning, succession planning, conflict management, strategic planning, human resource planning, financial planning, estate planning, and then exit planning. I mean, 3 days ago, UPL said that we are looking for a buyer because within family we have decided let's divest the business. And for a listed company which has a subsidiary spread all across the world, where you may have some private equity partners, some institutional partners, suddenly if you want to do it, it doesn't come easy. Very recently, Murgappa family executed their family settlement during COVID days, very nicely done. TVS family is right up in Supreme Court. I mean, I think as recent as in one of these days, matter was mentioned before Honorable Chief Justice Court that look, you should see our matter on out of turn basis. During COVID period, among several briefs, one of the briefs was an arbitration matter, which was purely on account of family related issues, where we were representing before an arbitrator comprising a very distinguished jurist of the country. So all that I can say, and of course we have great authority here, is the fact that how do you look at these small issues. आपने ट्रस्ट की बात करी गर्ग साहब, उसमें अभी सेक्शन 56(2)(10) पे बड़ी क्लैरिटी नहीं है, although I have a view
Yes.
that settlements in the trust where extended families are beneficiary, will you say that they do not qualify in the definition of relative and therefore 56(2)(10) is applicable? All of us have firm views and we've given opinions also, both in writing and otherwise also. I think this subject is such that you can continue speaking, but let's hear the discourse from the faculty of the day. And I'm glad, Garg Sahab, we've requested Jain Sahab to, and we have encroached, and he's been very kind enough to devote a couple of weekends for us along with his very young team. And thank you very much. Over to you, Jain Sahab. I think our audience is extremely keen, looking forward to it. I can tell you personally, amongst us, as part of our preparatory session, we've had 3 calls since morning to make sure that we are able to do justice with your diary and time. Over to you, Jain sir.
First, Bhavya, please introduce our guest speaker.
Thank you, Asim sir, for your kind words. Now it's been a privilege for us to have CA Vinod Jain ji as a guest speaker of today's session. Vinod Jain ji is a commerce graduate from SRC College in 1976. He has passed LLB in 1979 and he has passed his final examination with All India Rank 13. Vinod ji has about 38 years of experience in the field of taxation, audit, accounting, finance, banking, law education, and strategic planning and business management. He also is chairman of Inmex Management Services Limited. Vinod Jain ji also served as chairman of Board of Studies of the Institute of Chartered Accountants of India from 2010 to 2011, being in charge and overall responsibility for the chartered accountants education of about 1 million CA students in the country. He served as a chairman of Financial Market and Investor Protection Committee for 5 years, and he also is a member of high-powered committee appointed by Finance Ministry to simplify income tax law. He has been appointed as a government nominee director on the board of directors of Coal India Limited. I welcome you, sir. Also, I welcome your team, Advocate Ananya Madhusudan ji, Advocate Akhilesh ji, and Advocate Chavi Jain ji. Over to Vinod sir for technical deliberations.
Thank you very much. Thanks to Shri Sunil Garg ji for, of course, commencing and coordinating this entire session. Thanks to Avia Aslam ji, and of course, to start with, our guest of honor today, Shri Amit Agarwal ji, chairman of the session, Shri Asim Chawla ji, my colleagues from Inmex Law offices. I think I am very thankful to Sunil Garg ji, you and your team, including Shri Raj Chawla ji, to have given us this opportunity to convey our thoughts, knowledge, and experience with the participants. And we will, of course, go together as a team one by one. I think we have done some working together, how we are going to take which part, and that I think we'll coordinate among ourselves. So I think we like to actually put our presentation in front of everybody. Is that possible in this process? Because this particular style StreamYard we are doing first time. We do, of course, everybody else. We want to host our अनन्या आप करेंगे, कर पाएंगे? पूछिए जरा इनसे. मालविया कैसे करेंगे अपनी वो presentation यहाँ पर?
Look at that bottom right, bottom down. There will be a share button. So I think
share button. I don't see any share. No share button on my screen. It has
here
come
you
now.
go. Yeah. So
Very
then
good.
now I think.
Sir, I believe we can share. I'm going to give the
ये बड़ा हो सकता है, इतना छोटा स्क्रीन नजर आ रहा है,
yes,
लोग पढ़ नहीं पाएंगे.
I'm doing that. I'm doing that.
Can we make it bigger? The whole screen, if it can be. ये साइड में से comments और ये private chat ये सब हटा दीजिए. So that whole screen we see only the screen. I think Malvi is going to help us. And before, of course, we do that, I think I like to thank from core of my heart Shri Asim Chawla ji for the nice words he said, and of course the blessings which have come from Mathura. Sunil Garg ji, of course, have been regularly, we have been interacting together, and I think we have been working together on several webinars. So I think his knowledge is, of course, definitely going to help us in today's presentation also. So you want to say something in between?
No, go ahead. We just looking forward to this. If the audience is keen, with your permission, Jain Sahab, maybe we could. If usually we have these
Ja-
requests for sharing the presentation, so once you're done, and
The
if
presentation
you,
is, I think, already shared. If not shared, I think we'll share with Mavia, and I
yeah,
think it will
that,
be shared
yeah,
on YouTube as
जैन
well
साहब
as.
लोगों की मैं एक सेकंड लूंगा बस। जैन साहब लोगों की ये रिक्वेस्ट आ रही है कि चाहे आप 2 या 3 सेशन लीजिए, पर सर सारे टॉपिक कवर कर दीजिए।
yeah.
आप चिंता नहीं करिए, मैं कह रहा हूँ आप 5 सेशन लीजिए, मैं डिटेल में सारी चीज पढ़ाऊंगा सर।
ठीक है सर, थैंक यू
Very
सर।
good. Thank
ठीक
you.
है ना,
Most-
मैंने अपनी टीम के साथ यही कहा है कि हम जल्दी में कुछ नहीं करेंगे, धीरे धीरे
यस
करेंगे।
सर, इसीलिए
और
हमने एक
जिससे
दिन स्पेयर किया सर। 19 तारीख को, मार्च को हमने स्पेयर कर रखा है उसको। तो सर आप प्लीज टेक योर
आप
टाइम
ये
सर।
देखिए कि ये आपका इंटरेक्टिव है सेशन, ये कैसे करेंगे? क्वेश्चंस आएंगे तो
सर हम लास्ट में क्वेश्चंस लेंगे, और अगर आप
ओके।
बीच में लेना चाहोगे तो हम बीच में भी ले लेंगे सर।
नहीं नहीं,
आपके ऊपर
आपके
है
ऊपर, ये मेरे चाहने पर नहीं, आपके ऊपर है सुनील भाई। आप जब चाहें आप बीच में
सर।
कह सकते हैं, अभी ये सवाल है आप दीजिए।
हमारा फॉर्मेट ऐसे ही रहता है कि अभी आप 5:45 तक कीजिए, हम 5:45 के बाद क्वेश्चन लेंगे सर।
ठीक है जी, 5:45 से 6 तक, 6 के बियॉन्ड नहीं जाएंगे आज, थोड़ा मेरा कोई
हाँ, 6
कमिटमेंट
बजे
है
तक कर लीजिए, 6 बजे के बाद हम क्वेश्चन ले लेंगे सर।
नहीं नहीं, पौने 6 तक करेंगे, 6 तक ही क्वेश्चन लेंगे, मैं 6 के बियॉन्ड नहीं जाऊंगा आज।
ठीक है सर, ठीक है
Because
सर।
I have another commitment after 6, and
ठीक
maybe
है
we'll
सर।
do as many Saturdays you want, we are there.
ओके सर, थैंक यू सर, थैंक यू सर।
So I think if we can show this as a full screen, if you help us, Sunil bhai, so that it can really become full screen. I don't want it to be whether I'm seen or not, that is not important, but the screen people should be able to see in full.
So it is
तो
full
माविया
screen.
फुल स्क्रीन मेरे पास तो नजर नहीं आ रहा, फुल स्क्रीन पे मेरे पास तो बहुत छोटा सा नजर आ रहा है। सिर्फ प्राइवेट चैट आ रहा है, राइट में साइन ऑफ फॉर फ्री भी आ रहा है, ऊपर वेबिनार ऑन सक्सेशन प्लानिंग, ये वो बत्तख भी बनी हुई है, ये सब चीजें आ रही है। इनको किसी की जरूरत नहीं है, हमें सब हटा दीजिए।
तो ये YouTube पे लाइव जो हो रहा है वो फुल स्क्रीन पे शो हो रहा है।
Sir, at bottom right, please see there is an option for full screen mode, sir.
Yeah,
Bottom
on the right,
At the bottom right of the screen.
yeah, there is a square which is there. If you click that, it will come to full screen. On the right edge of the present, currently whatever is the size, just press on the right.
Sir,
edge.
where it is written private and confidential, just below that.
उन्होंने लिखा ही नहीं मेरे पास, प्राइवेट एंड कॉन्फिडेंशियल कहाँ है यहाँ?
Sir, in our PPT, sir.
यहाँ पर
आप जैसे कर्सर लेके जाएंगे ना सर, तब आएगा ये।
ओके, नाउ इट इज देयर। यस, थैंक यू। नाउ आई थिंक इट्स, अभी ठीक है, क्योंकि जब तक खुद को भी नजर नहीं आया तो प्रेजेंटेशन कैसे करेगा आदमी, राइट? So I think we'll go further. So I think as I will like to really go through now, I think we're now actually commencing the whole session. You know, ultimately succession planning is not just knowing the law, knowing what is happening around, but what is most important is what is this all about? क्यों करना क्यों है succession planning? Why succession planning? What are the basics and how to go about it? Because what we have seen out of our experience, you know, I've been doing succession planning exercises for about 25 years now in my 42 years of career. And I think every time we really learn. We also work with international lawyers from US, from UK, and various other parts of the world, because whenever there are international cross-border people involved. So I've worked with all kind of lawyers in respect of succession planning for people living in India, people living outside India, and of course, creating of succession setups in India and outside India, creation of trust in India, creation of trust in various parts of the world, including Singapore, including British Virgin Island, including Dubai and various other places. And how do we really, you know, ensure that we come out of the structures already created? There's several issues which we have really handled. But before we go into those details, I actually like to take you through what is the need and what is the importance of succession planning. And I think before we go to business succession planning, we will like to actually go into the personal succession planning. In this world, nothing can be said to be certain except death and taxes. That, of course, has been a very famous line. And some of the key reasons why do we undertake succession planning are in front of us. Most important being avoiding family dispute. Unless you plan properly, family dispute is likely to happen. unless your family is actually very, very matured and very, very sacrificing. So that is why it is very important for us to actually, we have seen Ranbaxy, we have seen Ambanis, we have seen Singalias, we have seen Ronak Singh ji and family, and several others. I think some more names are there. There's no point in taking names, but what is important is we see family disputes all around us. When we see our clients, when we see people known to us, when we see relatives, people after people are contesting with each other on several matters. Why? Because their fathers, their forefathers did not plan for themselves. हर आदमी को लगता है मुझे ये मिलना चाहिए, मेरे पिताजी मुझे देकर गए थे लेकिन मुझे मिला नहीं. And sometimes they give it to everybody in a hodgepodge, and nobody knows how to really use it. So I think we'll be first talking about personal succession planning. Then I think towards the complete end, we'll be talking about how to do the succession planning of businesses, including family businesses. That, of course, is going to be a highly technical piece. So before going to highly technical last piece, we like to go through step by step. And if some of you or most of you know some parts, I pardon you, because I like to go step by step so that nothing is missed. And we'll go through case laws and everything which our friend Asim ji was talking about. So what is personal perspective? Go back, please. And then I go to the last slide. Yeah. What is important is that we ensure provision of proper cash flows and look after for self. देखिए सबसे पहले कोई भी सक्सेशन प्लानिंग सेल्फ से शुरू होती है, अपने आप से खुद से शुरू होती है. अपने आप से खुद से क्यों शुरू होती है? Because there could be illness, there could be incapacity. I know very well a very, very close friend of mine. He was director of a 6,000 crore turnover company, and I've seen him that suddenly he finds himself that he is not able to recognize people, he is not able to take any decision, and he became practically incapacitated to take any decision about himself. And he was a bachelor, owning, of course, crores and crores of assets. What to do, where and what to do, nobody knows how to manage cash flow for him. Of course, he was alone. But people who are fully with their close relatives and everybody, then the relatives may start working whether to provide this cash flow, that cash flow to this person or not. आपकी वेल्थ बहुत होगी पर आप तक कुछ नहीं पहुंचेगा. आपकी मेडिसिन के लिए, आपके डे टू डे जरूरत के लिए, तो ये सबके लिए प्लान करना जरूरी है. तो सबसे पहले सक्सेशन प्लानिंग में खुद के लिए प्लान करें कि आपकी कोई इलनेस हो सकती है कल को. बिकॉज आजकल देखिए टुडे द life expectancy has become very large, very long. Earlier, very, very few people were working going beyond 60 or 65. Now people go up to 80, 90, 100. And as you move towards 70 and beyond, the illnesses become more and more. And I think that is where you need to really plan every affair when you are in your maybe early 50s and maybe even earlier. So, of course, you need to ensure accommodation, funding of basic expenses and maintenance, allocation of specific assets to relevant successors. That, of course, is very important. Ensuring devolution of property does not happen to unintended beneficiaries. अभी जिसको आप नहीं चाहते उसके पास ना चला जाए, ये भी एक देखिए बहुत जरूरी चीज है. जैसा सुनील जी एग्जांपल दे रहे थे, उससे एक सिमिलर एग्जांपल मैं देता हूं. It happened in one of our clients' case. He was holding shares in a large company, about 25% shares, and suddenly, of course, he died. Everybody died suddenly. Once he died suddenly, he had left two sons. Of course, wife was also alive, and his mother was also alive. And he has several brothers and sisters. As soon as he died, just after 3 days, his mother also died. Now the things become very complex. You can really see how the things become very complex is that on his death, the inheritance of his huge asset, of course, is to be divided, and it has to go to the mother. And then from mother, on the mother's death, the mother's share will also have to go to his brothers, sisters, and maybe several other people. So I think that is where one need to really see whether it goes in the absence of a proper succession planning, in the absence of a proper will. It can go to unintended beneficiaries where you may not really want it to really go. Disproportionate distribution of assets. You may not want to do a proportionate distribution of assets among all your heirs, because as far as succession planning through the succession law is, unke liye to sab barabar hai depending on the relationship. They do it only on if Mr. A has died, what relation you have with him, this much share is going to come. on a particular proportion which is decided based on who are the other heirs. But if you want to give disproportionate distribution of assets, then of course succession planning is definitely necessary. You want to give something more to somebody, you want to give somebody less to somebody, and you don't want to give anything to somebody. So I think that can be done only through succession planning. Ensure proper supervision, proper provision for the spouse. देखिए स्पाउस के आगे की बात मैं अभी बाद में करता हूँ, स्पाउस एंड चाइल्ड की, खासतौर पे स्पाउस की बात मैं करना चाहता हूँ. One has to really see it very carefully, because in my own practical experience of last 42 years working experience and my life experience of about 64-65 years, what I've seen is that a female is the landlady and lord of the house till the time her husband is alive. As soon as the husband goes, in most of the houses, her position is not less than a beggar, actually. That is what we have seen, and that is what we really need to avoid, because you might have earned crores and crores of rupees, but if you don't plan it properly for your spouse is going to be high and dry. Maybe your children, whether they'll give something to the spouse or not, whether they take away everything, or whether they really give her share. Even if you write a will, even then several parts you need to really plan properly. Succession planning is not only writing a will, it is much more than that. I think that we are going to really learn what to do, what not to do. Similarly, of course, child के लिए तो सब करते ही हैं. उससे अगला important parents के लिए. Suddenly you might be 35 years, you might be 40 years. Sometime, people lose their life unplanned, अकाल मृत्यु हो जाती है. मैं कहता हूँ 60 की साल में भी अगर आप हैं, आपके पेरेंट 80-90 साल के हैं, उनके लिए भी आपने देखना है. You have to provide for their special care and regular cash flow. देखिए ये चीजों का सबका ध्यान रखना जरूरी है. बाकी देखिए कानूनी बातें हम करेंगे, लेकिन सबसे पहले मन की बात करेंगे. Because whenever I do succession planning, I say it is a balancing of love, money and control. ये 3 शब्दों का ध्यान रखिए. प्यार करिए, पैसे को संभाल के रखिए, लेकिन कंट्रोल प्रॉपर रखिए. कैसे तीनों को बैलेंस करना है, लव को, पैसे को और कंट्रोल को, that is we are going to really learn together. Let's go to the next slide please. देखिए बिजनेस पर्सपेक्टिव, ऑल्दो हम आज डील नहीं करने वाले, बट फिर भी ब्रॉडली टू इंट्रोड्यूस business perspective, succession in family businesses of ownership and management, instability in control over companies owned by the family, ensuring continuity of family business, identifying role of the next generation, running of new businesses, use of family brand, right to liquidate holdings, and ring fencing of certain properties. ये सारे issues हैं जो business perspective में हम लोग देखेंगे, but that we will be looking at towards the end of our exercise actually. So I think we go further to the next slide. Now, succession planning is, of course, a formalized process to successfully transfer company leadership from current management to successor management. This also, I think, we are going to see possibly in the towards the end. But broadly, just to give you an idea, we'll be dealing with family charter, we'll be dealing with family business rules, family ethics and culture, family business meetings, family council meetings, grooming of successors, management processes, family governance, shareholders agreement, so that the management succession and notice succession can really happen properly, and the desired outcome can come from integrated family members. They have assessed option, informed decision making, and everybody is given their comfort level. I think मैं जल्दी इसलिए कर रहा हूं क्योंकि हम तीसरे दिन इन सारे इश्यूज को डिटेल में करने वाले हैं. अब देखिए हमारा प्रोसेस जो शुरू होता है, पर्सनल सक्सेशन प्लानिंग का प्रोसेस शुरू होता है इंसान से खुद से. अगर आप समझिए आप मेरे सामने बैठे हैं और मैं आपके लिए सक्सेशन प्लानिंग कर रहा हूं, तो इसी तरह से सवाल जब हम आपस में करने वाले हैं, तो सबसे पहले आपने देखना है, यू आइडेंटिफाई योर ओन स्पेसिफिक गोल्स. ये मैं इस तरह से आपसे इसलिए बात कर रहा हूं कि जैसे आप सब लोग चार्टर्ड अकाउंटेंट हैं या लॉयर्स हैं, यू कैन टॉक टू योर क्लाइंट्स अकॉर्डिंगली. तो आपने आइडेंटिफाई करने अपने खुद के गोल्स. आपने एक एडवाइजर जरूर चाहिए आपके साथ आपको एडवाइस करने के लिए, एंड उसके साथ मिलकर आपने डिवाइस करनी है बेस्ट स्ट्रेटेजी टू अचीव योर गोल्स. Because people and their goal are different. Because people are different, their goals are bound to be different. Circumstances are different from person to person. Strategies and processes needs very, very careful crafting. कई बार लोग कहते हैं कि भाई हम तो सर ऐसा करते हैं, हम कॉपी कर लेते हैं, वो विल पड़ोस वाले ने बनाई है, उसकी विल लाके उसमें कॉपी करके सिर्फ ऐसे ही तो चेंज करनी है. तो जो लोग ऐसा करेंगे, they will be of course in a very big soup of their life actually. कुछ लोग देखा देखी दूसरा क्या कर रहा है सिर्फ दूर से देख लेते हैं, and then they copy. But I think this is a very, very important thing, and we should not really actually play with ourselves. We should not play with our successors in any case. So people and goal are different, so we need to actually do it differently. Now the question comes before us, how do we determine what our goals are? आप पूछेंगे भाई मुझे क्या पता मेरे goals क्या हैं, कैसे पता लगे? How do I begin the estate planning process? Who can help me develop my estate plan? ये तीनों सवाल आपके मन में बार बार आएंगे, और इन तीनों का सवाल का हल लेने के लिए आपका क्लाइंट ने आपके पास आना है. तो जब आपका क्लाइंट आपके पास आएगा, वो आपसे पूछेगा भाई मुझे नहीं पता मेरे गोल्स क्या हैं. गोल क्या होता है मुझे ये भी नहीं पता सही मायनों में. आप क्या पूछना क्या चाह रहे हो? What do you really want to understand from me? What is my goal? My goal was to become a chartered accountant. I become. My goal was to become a businessman. I have already become a businessman. My goal was to create large business. I have already created large business. So what do you really mean by what is my goal? तो चलिए नेक्स्ट स्लाइड पर देखते हैं. तो बिफोर वी गो फर्दर, हमें अपने दिल को और झांकना. देखिए मैंने बताया ना, लव मनी कंट्रोल में ये दिल का मामला है. सबसे पहले अपने दिल में झांक कर देखिए व्हाट इज इन योर हार्ट, नॉट रियली व्हाट यू हैव मेड नोट्स ऑफ. हर आदमी आता है आपका कुछ ना कुछ नोटिंग करके आता है कि मैं ये ऐसा सोच रहा हूं, ऐसा करूंगा. तो सबसे पहले से बताइए, पहले अपने दिल में सोचिए कि आपका दिल क्या चाहता है. और ये सारे फैसले जो सक्सेशन प्लानिंग के हैं सही मायने में दिल से करने पड़ते हैं. दिमाग तो चाहिए, लेकिन अगर आप उसमें अपने दिल नहीं लगाएंगे तो दिल कहीं रह जाएगा, और दिमाग से सिर्फ आप एक मैकेनिकल से काम कर लेंगे जिससे ना आपको तसल्ली होगी, ना जिनके लिए छोड़ के जा रहे हैं उन्हें तसल्ली होगी. तो व्हाट इज इन योर हार्ट इज वेरी वेरी इंपॉर्टेंट टू बैलेंस द लव पार्ट ऑफ इट. लव मनी एंड कंट्रोल में लव का पार्ट बहुत इंपॉर्टेंट है जो हार्ट से शुरू होता है. तो इसलिए पहले अपने हृदय में झांक के देखिए आप चाहते क्या है, उसी हिसाब से प्लानिंग करेंगे. वी गो टू द नेक्स्ट. द गोल 1, सबसे पहला गोल हमारा क्या? प्लान फॉर द लव्ड वंस. जिन्हें हम प्यार करते हैं, जो हमसे प्यार करते हैं, हमें उनके लिए प्लानिंग करनी है. टू प्रोवाइड फॉर द फैमिली. फैमिली मैंने बताया, इट कुड बी माय चिल्ड्रन, कुड बी माय पेरेंट्स, कुड बी ऑफ कोर्स माय सेल्फ, माय स्पाउस. इन एनी केस व्हाट इज इंपॉर्टेंट फॉर देम आई नीड टू आइडेंटिफाई. उनके लिए एक एक आदमी के लिए आपको सोचना पड़ेगा. बेटे के लिए क्या जरूरी है, बेटी के लिए क्या जरूरी है, वाइफ के लिए क्या जरूरी है, फादर मदर के लिए क्या जरूरी है. एक एक चीज को ध्यान से देखिए, व्हाट इज इंपॉर्टेंट फॉर देम. बिकॉज ये सबके लिए एक सा नहीं हो सकता, सबके लिए अलग अलग है. किसी के फादर मदर दोनों होंगे, किसी की खाली मदर होंगी, किसी की मदर बहुत एक्टिव होंगी, किसी की मदर एकदम इलिटरेट होंगी. यू नो देयर, किसी के फादर बहुत समझदार होंगे, किसी के फादर बहुत कुछ और ट्रेट्स उनके साथ हो सकते हैं. तो जैसे हैं उसको उसी हिसाब से वी हैव टू लुक आफ्टर देम, वी हैव टू टेक केयर ऑफ देम बिकॉज दे लव फॉर अस एंड वी लव टू देम. हाउ टू एक्ट टू टेक केयर ऑफ, एक मिनट बेटा पीछे. How to act to take care of disabled or heirs of deceased family members. ये देखिए एक ये और बड़ा इंपॉर्टेंट हिस्सा है कि हाउ टू टेक केयर ऑफ डिसेबल्ड, जो अपने परिवार में, अपने रिश्तेदारी में, अपने क्लोज नेट में डिसेबल्ड हैं. कुड बी यू कैन से फॉर एनी रीजन, या हियर्स ऑफ अ डिसीज फैमिली मेंबर. हो सकता है किसी के घर में बहन के बच्चे आपके परिवार में रहते हैं क्योंकि बहन और उसके हस्बैंड चले गए, या कोई और फैमिली मेंबर है, क्लोज फैमिली मेंबर, उनके बच्चे आर एसोसिएटेड विद योर, तो उनके जो हियर्स हैं उनको भी आपने लुक आफ्टर करना है, डेफिनेटली देखना है. तो ये नहीं है कि हाँ सिर्फ नहीं मैं एम ओनली कंसर्न अबाउट माय वाइफ एंड माय चिल्ड्रन. जो ऐसा सोचते हैं दे आर ऑल इन प्रॉब्लम, दे आर ऑलवेज इन प्रॉब्लम एक्चुअली. सो सबसे पहले हमें देखना है कि कौन हमें प्यार करते हैं और हम किसको प्यार करते हैं. तो दिल से देखिए और उस हिसाब से आगे चलिए. नेक्स्ट प्लीज. प्लान टू पास ऑन योर लीगेसी. तो खाली हमने एसेट नहीं बेचनी है, एसेट ही नहीं देनी है लोगों को, क्योंकि हो सकता है आधे से ज्यादा, हो सकता है 70% लोगों का मन ये है किसी तरह भी एसेट में डिस्पोज ऑफ कर दूं. लेकिन व्हाट इज मोस्ट इंपॉर्टेंट, जो आदमी जा रहा है, जिस आदमी ने 30 साल 40 साल 50 साल 60 साल 70 साल लगा दिए अपने लाइफ के, उसके लिए बड़ा इंपॉर्टेंट है कि जो वैल्यूज, जो फैमिली वैल्यूज और बिलीफ उसे मिले हैं, दैट इज कैरिड ऑन इन हिज फैमिली. द फैमिली हिस्ट्री इज वेरी इंपॉर्टेंट which I need to actually share with all my people. Family tradition and culture, हमारे यहाँ ये होता है, हमारे यहाँ ये नहीं होता है, हमारा कल्चर ये है, हमारा कल्चर ये नहीं है. ये सारी चीजों को it is very very important for you to actually create that. It is now time, it has come that you start, because this is the most important part of our succession planning. पैसा तो फिर भी आपके जो सक्सेसर हैं कमा लेंगे, क्योंकि वो है, हमारे यहाँ कहावत है, पूत सपूत तो क्यों धन संचय, पूत कपूत तो क्यों धन संचय. लेकिन सबसे इंपॉर्टेंट बात यह है कि वे अगर आपकी फैमिली कल्चर को, फैमिली हिस्ट्री को, फैमिली ट्रेडिशन को, फैमिली वैल्यूज को और फैमिली बिलीव्स को अगर वो फॉलो नहीं करेंगे, तो डेफिनेटली यू as their your successor, you will never like the way they are doing it. So it is important to create a well-documented personal family history for communication to children and grandchildren in certainly a meaningful estate plan. तो देखिए बहुत जरूरी है, ये मैं इस बात में हर लेक्चर में हर साथियों से अपने कहता हूं कि अपने बच्चों को, अपने ग्रैंड चिल्ड्रन को अपने बारे में बताएं, आप बीती बताएं, आपके फादर्स के साथ क्या हुआ वो बताएं, पहले पुराने इतिहास में क्या हुआ और किस वजह से फैमिली ऐसा सोचती है। क्योंकि आज के जो संस्कार हैं, आज की जो आप समझिए जो जनरेशन है, वो सिर्फ आपके कहने से नहीं, हमारे यहाँ ऐसा नहीं होता, वो नहीं मानने वाली है। यू हैव टू डेफिनेटली गिव देम व्हाई वी एज अ फैमिली हैज डेवलप्ड दिस कल्चर, व्हाई वी एज अ फैमिली हैज डेवलप्ड दीज वैल्यूज एंड बिलीव्स। ये व्हाई जो है उनको धीरे धीरे आप अपने एक्सपीरियंसेस जब शेयर करेंगे तो उनके सामने आ जाएंगे। You need to, of course, plan to avoid probate and intestacy. You need to definitely avoid taking a probate. And of course, a intestate. What is intestate? Is dying without leaving a will or dying without, properly allocating is intestate death actually. वो हम आगे जाएंगे तो धीरे धीरे समझ में आ जाएगा। Fourth goal is plan to minimize taxes. And fifth goal is plan for your own or your spouse or children or parents' disability. किसी की भी डिसेबिलिटी होती है, पांचवा गोल है मेरी अपनी डिसेबिलिटी, स्पाउस की, चिल्ड्रन की, पेरेंट्स की, किसी की भी डिसेबिलिटी होती है, उसको अलग से आपने प्लान कर रहे हैं। एक एसेट देनी उन्हें, मनी जनरेटिंग, कैश जनरेटिंग एसेट देनी है सक्सेशन के लिए, वो एक अलग बात है, बिजनेसेस देने, पर अगर वो डिसेबल हो जाएंगे तो कैसे लुक आफ्टर होंगे, ये देखना बहुत जरूरी है। वी गो टू द नेक्स्ट प्लीज। देखिए टैक्स जो है सही महीने में हमारा सेशन नहीं है, ये लिखा है दिस विल डिस्कस डिटेल इन नेक्स्ट सेगमेंट, बट आई थिंक वी विल अवॉइड डिस्कसिंग टैक्सेशन पार्ट, क्योंकि टैक्सेशन में हमारे साथ चावला जी हैं, असीम चावला जी ऑफ कोर्स इज अ ग्रेट टैक्सेशन एक्सपर्ट। राज चावला जी खुद भी एक बड़े अच्छे टैक्सेशन एक्सपर्ट हैं। टैक्सेशन में हम लोग भी बहुत गहराई से जाते हैं, बट क्योंकि हमारा सारा फोकस सक्सेशन रिलेटेड होगा, फिर भी जहां पॉसिबल होगा हम टच करेंगे टैक्सेशन एस्पेक्ट को, बट हम गहराई में नहीं जाएंगे टैक्सेशन की। तो प्रोसेस हमारा चल रहा है, देखिए स्टेप सक्सेशन प्लानिंग के आ रहे हैं। Ananya, will you carry it from here to for some time? Ananya, are you there? She's there, Ananya. Akhilesh, Ananya is around.
Yes, sir. Just 1 second, sir. I'm just starting.
Yeah, we start from here. Yeah, so go ahead. Screen चली गई, वो नहीं आ रही है सामने. Where is the presentation?
Sir, 1 second, please.
Presentation is missing. It is not in front of us.
Right. Good afternoon, everyone. So when we're talking about succession planning steps, what do we have to focus on? First of all, you have to make a list of all the assets we have. Simultaneously, we also have to make a list of all the liabilities, primarily because our successors have to keep in mind what benefit with respect to asset they're getting, and simultaneously what liabilities they have to sort. So it's very important to list out all the assets one's own as an individual before commencing the whole succession planning process. So what things we have to keep in mind? Whether the asset is wholly owned or jointly owned with other people. So for instance, if you have a property jointly owned with another family member, for instance, your mother or father, or with your husband or wife, irrespective. Whether the person, the legal owner of the property, is sought to be bequeathed, which means that whether you have the rights to it to actually transfer it or make it in your succession plan to transfer to someone else, or whether if a person is a member of an HUF, whether the asset intended to be bequeathed is a HUF property or self-acquired property. This is a very complex topic, whether it's a HUF property or self-acquired property, primarily because HUF property is considered to be a family property, and self-acquired property is something which you've acquired from your own income. So if you're a member of HUF, whether you've given a particular property to the HUF or you've kept it as a self-acquired property, these are factors which you have to consider. If a person is trustee, whether property is intended to be bequeathed as self-acquired property, where the location is the asset, whether it's in your area of residence or it's outside India or in some other part of the state. On what's the nature of asset, whether it's a movable asset, movable property, or immovable property. So these are basic lists and liabilities which you have to list of assets and liabilities which you have to keep in mind. Thereafter, then next step comes in determination of fiduciary and beneficiaries. So it's very important to determine who is going to be a beneficiary of a property in future. And I'm talking about property from the perspective of movable and immovable. So it's, and this is a very difficult process because at a lot of instances we keep in mind of our emotional aspect more, and that it's what our heart wants more. However, at the end of the day, it's very important that we have to select people who will assist in carrying out our wishes as an individual and undertaking the whole succession planning exercise for the benefit of a near or dear person. Thereafter, the main planning tools of succession planning are wills and trusts. Will is basically a document which puts forward put forth the wishes of the person who's the testator or testatrix regarding the distribution of his or her property, and how the property has to be distributed for the care of the beneficiary or the next of kin. Properties in the will can be directly bequeathed or bequeathed through a trust or another individual who handles the entire process. Trust, on the other hand, is a fiduciary relationship between the settler and the trustees, where the settler gives the trustee the right to hold title to the property or assets for the benefit of a third party. Trust can be based on on the ultimate object. A trust can be revocable, irrevocable, discretionary, determinate, which we'll discuss further during our next course of presentation. Now, other things which you have to keep in mind while we are doing the entire process of succession planning is family constitutions. So, for instance, family constitution is a document which basically sets out the rule for transition of family business from one generation to another. Uh, as practicing CAs, a lot of us would experience that our business, if you have to carry out to our next generation, what do we expect out of them and how we want them to continue our business. So for that purpose, we build the family constitution, which comprises of family tree, family values and objectives, roles and responsibilities of the concerned members, business relationship, and certain do's and don'ts. We also have another thing called as family offices, where we manage multiple businesses and investments of a family on a day-to-day business uh, basis, which is not necessarily a role of the key managerial persons of the main company. To address this, business families are setting up family offices which run and manage the family business independent of the main company. And thereafter, we have professional roles, which is important to guide the entire process. You hire an external advisor to guide you through the entire process, who plays uh, the role of as a general neutral role. Now, as an individual, what are the things we have to keep in mind? First of all, whether we have a succession plan document, whether we have a will, whether we have a trust document, or whether we have anywhere written down what we expect out of our successors, which is very, very important, which is the first step. And
I'll take this, and then I'll just take this here.
Yes.
I'll just supplement here. This succession planning document, whichever as Ananaji was explaining, whatever may be the document, whether it is trust or whether it is a trust deed or whether it is a will or it is any other, supporting paper, implementation paper. I think Akhilesh, of course, is regularly drafting with for us various kind of implementation papers. It is important for us that जिसके लिए बना रहे हैं आपका जो क्लाइंट है, he actually understand it carefully. Because unless he understand, आपने बहुत भी अच्छा document बनाया, if he has not understood, it is possible that you are not able to do what he really want. You need to be very careful that it is very clear in the document that asset will pass to whom you want. जिसको चाहते हैं उसी के पास जाएगी. The way you want उसी तरह चाहेगी. और जब जानी चाहिए जब ही जाएगी, उससे ना पहले जाएगी ना डिले होगी. ये तीनों एस्पेक्ट को एक तो इसे एड्रेस करना जरूरी है सक्सेशन प्लानिंग डॉक्यूमेंट को. डज द एग्जिस्टिंग प्लान एड्रेस, अब आपका कोई एग्जिस्टिंग प्लान है तो उसे देखिए, रिव्यू करिए कि वो आपके गोल्स को, जो भी अभी गोल्स की मैंने चर्चा की, उनको मीट कर सकता है या नहीं कर सकता है. पर्सनल, फैमिली, फाइनेंशियल पोजीशन, सिचुएशन, ये सारी चीजों को एड्रेस करता है नहीं करता है. आपकी पर्सनल रिक्वायरमेंट को, फैमिली के रिक्वायरमेंट को, फाइनेंशियल पोजीशन को, आपकी सिचुएशन को. और ऑफ कोर्स wherever you need help, it is important to consult a good succession planner. A good chartered accountant or a good lawyer could be, of course, your best solution. but of course somebody who has experience of handling such matters in a manner, in a very matured, in a very methodical manner. A state and succession planning profession is actually your answer. We go to the next, Dana ji.
Correct.
अब
So,
चलिए आगे,
uh,
चलिए आप चलिए. Anina, go ahead. या यहाँ
right.
से चलिए.
So, this was a basic idea we wanted to give you, everyone, the audience, about the succession planning. However, from here on, we'll discuss about with respect to the different what is succession planning if a person dies without a will or without any document evidencing their future wishes. So we've already discussed what we're looking for. That in a business perspective, the one is to either structure the organization or avoid the insolvency process. But the best solution would be to have a proper succession plan in place. If in case that does not happen, then what is an individual supposed to do, or how to continue forward? So in that case, for Hindus, Buddhists, Sikhs, and Jains, if a person dies without a will, individual dies without a will, they're governed by Hindu Succession Act. um, Parsis are governed by Chapter 3 of Indian Succession Act. Muslims are governed by the Personal Law, which is Muslim Personal Law Shariat Application Act. And Christians are governed by the Indian Succession Act. Now, when we're talking about this, what is testament? There is a difference between interstate and in testamentary succession. So, interstate is when the person is governed by their respective personal laws and they've died without a will. And testament succession is with respect to the fact that they have a will in place. So, Hindu Succession Act, for instance, permits the Hindus to dispose of their particular property by will, um, or their movable property as per their wishes. And with respect to Indian Succession Act, and it allows any person of sound mind, except Muslims, to dispose of their property by will. So this is where we've given you a brief idea of how the whole succession process works for different.
Can you go back to the earlier slide,
Right.
Ananya? Huh? Just go back to. It is also very important for us to understand the way the succession law is governed in India. As far as Hindu succession law is concerned, anybody who is not a Parsi, Muslim, or Christian, it is assumed that going to be governed by Hindu succession law. सो अगर आप क्रिश्चियन नहीं हैं, आप मुस्लिम नहीं हैं, आप पारसी नहीं हैं, इसके लिए आप कोई भी धर्म मानते हैं, चाहे आप सनातन धर्मी हैं, चाहे आप जैन हैं, चाहे आप सिख हैं, चाहे बुद्धिस्ट हैं, या और भी कोई धर्म मानते हैं. आज तो देखिए बहुत सारे धर्म हैं, इतने सारे धर्म गुरु हम देखते हैं हमारे आसपास हैं पूरे देश में, पर सबके लिए तो व्हाट द हिंदू इंक्लूड्स एनी पर्सन अदर देन पारसी, मुस्लिम, ज्यू एंड क्रिश्चियन. ज्यूज को भी इंक्लूड नहीं करता है. Jews, ये यहूदी जो I think primarily these people are based in Israel. So Jews, Christians, Muslim and Parsis को छोड़ के बाकी सब लोग everybody gets covered into the definition of Hindu. और जो भी हिंदू है वो हिंदू सक्सेशन एक्ट के अंतर्गत आएगा. That is very important for everybody to understand. So I think about 99% of our audience today will be actually covered by the first clause. That is what is governed by Hindu, Buddhist, Sikh, and Jain. Of course, in balance 1% of our audience will, of course, have a lot of good Muslims and Parsis and Christians also here. So I think we are going to address all those issues. We go further on energy if you want to, or I can go further. You go to the next slide. So when an individual dies, of course, without a will, then of course we have seen that it is divided into different portions. Muslims are dealt with separately as per Shariat and as per, of course, Muslim law. Indian Succession Act governs the Christians, Parsis, Jews, and of course Hindus, Jains, Sikhs, Buddhists, and all others who are neither a Christian nor a Parsi nor a Jew and nor a Muslim are all governed by Hindu Succession Act 1956. And once you make a will, then of course you are governed by Indian Succession Act. Whether you may be Hindu, you may be Jain, you may be Sikh, you may be Buddhist, you may be Parsi, or you may be a Christian or a Jew. They are all governed by Indian Succession Act. Muslim, of course, have a different special law for themselves, and they are, of course, an overriding law. And wherever the law is overriding, of course, the Muslim Shariat law will prevail there. We go to the next, please. ये सेक्शन 3 में वही बात है जो हम अभी कर चुके हैं कि हिंदू कौन है, हिंदू कौन नहीं है. ये उसी की डेफिनेशन को लिखा है. I don't think we need to really go through it. You can go to the next slide. अब ये थोड़ी सी कुछ डेफिनेशंस हैं जो समझनी जरूरी हैं. ऑल्दो याद करने की जरूरत नहीं क्योंकि हमें एग्जाम नहीं देने, बट मोटा मोटा समझ लें. Agnate, one person is said to be agnate of another if two are related by blood or adoption wholly through males. तो मेल्स के थ्रू अगर आप रिलेशन है, आपका चाचा ताऊ वगैरह के थ्रू आपका जैसे जो भी रिलेशन है, then you are an agnate actually. Cognate, one person is said to be cognate of another if two are related by blood or adoption but not wholly through males. That means it is not wholly through males. They are partly male, partly female. Full blood, two persons are said to be related to each other by full blood when they are descended from common ancestor by the same wife. When they are descended from a common ancestor but the wives are different, then of course they are called half blood. And uterine blood is two persons said to be related to each other by uterine blood when they are descended from a common ancestor but by different husband. So different husband is uterine blood, half blood is different wife, full blood is same ancestor and same wife, and of course cognate agnate we have understood. Cognate is relationship through males and through females, and of course agnate is relationship through males. Cognate may not entirely through males. Go next please. देखिए अब ये सवाल जो एचईएफ प्रॉपर्टी वाला है इसको समझेंगे हम लोग बहुत ध्यान से, क्योंकि ये बहुत कॉम्प्लेक्स लॉ है. और ये जैसा हम लोग सब चार्टर्ड अकाउंटेंट भाई आज तक समझते आए हैं, उससे लॉ ये काफी आगे निकल गया है. लॉ में बहुत बड़ा बदलाव आएगा इन लास्ट फ्यू इयर्स, मोर बाय जुडिशरी देन बाय ऑफ कोर्स बाय द रिटन लॉ आल्सो, बट द जुडिशियल प्रोसेस हैज ऑफ कोर्स मेड अ वेरी सब्सटेंशियल डिफरेंस. Before Hindu, Ananya, wherever necessary, you can please supplement me, okay?
Definitely.
Because I think we have done a lot of work together on this. Before Hindu Succession Act 1956, immutable properties amongst the Hindus were considered co-partnership properties, wherein only male heirs had the right to property. The right was acquired in the co-partnership property by a male heir by virtue of his birth. The share in the property varied with the birth and death of a male Hindu. ठीक है, सिर्फ जन्म से ही आप अधिकारी बनते थे और मृत्यु के बाद आपका अधिकार चला जाता था. Such families were addressed as joint Hindu family and also known as Hindu undivided family. देखिए हिंदू अनडिवाइडेड फैमिली की ये डेफिनेशन है जो हमेशा सदियों सदियों से चली आई है. Whether it could be any kind of whether Daya Bhaga or Mitakshara, whichever school of thought you are, broad thing is a person once a male once he is born into the family, he was born with a right to the asset. When he dies, he leaves the assets in the family and he has no continuing right in the family assets. Now, the next step, women were the members of the HUF. However, they were not co-partners. One thing that they can be noted that that a daughter, wife or mother did not have directly any right in the HUF property. Their rights accrued only after the death of the related male member to them. Their right to HUF property comes not in their direct individual capacity, but this only arises as heirs of the deceased after the death of the male member with whom they are directly related to. ये देखिए बहुत इंपॉर्टेंट बात है समझने वाली. एक एक करके स्टेप बाय स्टेप समझेंगे, because this process has undergone a big change over a period of time, and I think we are going to take you through the change. Therefore, due to this reason, they were also unable to claim partition during the lifetime of their related male members of the HUF family. तो देखिए प्री 1956 ये लॉ था, 1956 से पहले, क्योंकि ऐसे ना, क्योंकि कानून के बारे में जो भी नॉलेज है हमारे समाज की वो एक पीढ़ी से दूसरी पीढ़ी को बताई जाती है, उसी तरह लोग समझते हैं. बहुत कम ओकेजन होते हैं, जैसा आज हमें चावला जी ने बैठा लिया साथ में सुनील गर्ग जी ने, कि हम साथ बैठ के समझ रहे हैं भी ये लॉ पहले कैसा था, आज कैसा है, आगे क्या होगा, इसको हम समझने का प्रयास कर रहे हैं. तो प्री 1956 लॉ वाज लाइक दिस कि आप जन्म हुए तो आप मेंबर बन गए, आपका हक हो गया अगर आप मेल मेंबर हैं, आप फीमेल हैं तो भी आप मेंबर बन गए, आप शादी होकर आ गए तो भी आप मेंबर बन गए, और आप पैदा हुए उस घर में लड़की के तौर पर तो भी आप मेंबर बन गए. आपकी शादी हुई, डॉटर की शादी हुई, उस दिन से शी सीज्ड टू बी मेंबर ऑफ द HUF. ये दिस वाज द प्रोसेस प्री 1956. तो जब तक हिंदू सक्सेशन एक्ट नहीं आया था तब तक यही सिचुएशन थी. फिर हिंदू सक्सेशन आया 1956 में, हम आजाद हुए उसके बाद. तो हिंदू सक्सेशन एक्ट ने क्या किया? लेट अस गो टू हिंदू सक्सेशन एक्ट. अब 1956 से 2005 तक एक बहुत लंबा अरसा देखिए, आप समझिए लगभग कितने साल हुए? आई थिंक अबाउट 50 years, almost about 50 years. Hindu Succession Act 1956 was introduced as a progressive legislation which for the first time provided effective rights of women in the property. Although ऐसा कहते हैं कि हमने इंट्रोड्यूस किया, पर मैं आज भी नहीं मानता कि वीमेन को इफेक्टिव राइट है प्रॉपर्टी में, इवन आफ्टर ऑल अमेंडमेंट. मैं एक्सप्लेन करूंगा आपको क्यों मैं ये बात कह रहा हूं, वंस आई हैव ऑलरेडी एक्सप्लेन यू द लॉ. So because women are still not adequately looked after even in the current law in my view. Hindu Succession Act 1956 are introduced as a progressive legislation which for the first time provided effective right of women in the property. ऐसा हिंदू सक्सेशन लॉ ने कहा खुद. सेक्शन 6 बड़ा इंपॉर्टेंट है, देखिए 1956 के लॉ का. In the opening line it mentioned that the property shall devolve by survivorship. However, where there is a female here or a male claiming through a female, the devolution shall take place under the law. तो उन्होंने कहा कि नॉर्मल कोर्स में सर्वाइवरशिप का कानून चलेगा, लेकिन जहां जहां कोई फीमेल हियर होगा या कोई मेल होगा क्लेमिंग थ्रू ए फीमेल, द डिवोल्यूशन शैल टेक प्लेस अंडर दिस एक्ट. अब अंडर सेक्शन 6 द सक्सेशन वाज डिवाइडेड टू 2 पार्ट्स. सक्सेशन इन रिस्पेक्ट ऑफ को-पार्टनरी प्रॉपर्टीज, दैट इज एचयूएफ, देन सक्सेशन इन रिस्पेक्ट ऑफ नॉन को-पार्टनरी प्रॉपर्टीज. अब देखिए यहां देश दो हिस्सों में बढ़ गया. एक तो को-पार्टनरी प्रॉपर्टी, एक हो गई सेल्फ एक्वायर्ड प्रॉपर्टी जो नॉन को-पार्टनरी प्रॉपर्टी है, फैमिली की प्रॉपर्टी नहीं है, आपकी अपनी प्रॉपर्टी है. Whenever a male Hindu having an interest in the मिताक्षरा को-पार्टनर प्रॉपर्टी died, ज्यादातर हमारे देश में मिताक्षरा या दया भागा साउथ साइड में ज्यादा है, या बंगाल में भी दया भागा है, पर अब तो खैर आज की डेट में सिग्निफिकेंस मिताक्षरा दया भागा की लगभग खत्म हो गई आफ्टर द 2005 लॉ. Whenever a male Hindu having an interest in Mitakshara co-parsonage property died after the commencement of this act, then his interest in the property would devolve by rule of survivorship and not in accordance with the act. However, if the Mitakshara co-partner died leaving a female heir of class 1 or a male heir claiming through her, then the interest would devolve by testamentary or intestate succession in accordance with the act, and rules of survivorship is inapplicable. तो इन्होंने रूल ऑफ सर्वाइवरशिप की एक एक्सेप्शन निकाल दी कि अगर मिताक्षरा का को पार्टनर है, दया भागा के लिए अप्लाई नहीं किया. इफ ही डाइड बिहाइंड ए फीमेल, लीव ए फीमेल हियर ऑफ क्लास 1 और ए मेल हियर क्लेमिंग थ्रू हर, देन द इंटरेस्ट, मतलब या तो आपने मतलब फीमेल हियर छोड़ा, या मान लिया उसका मेल हियर है, शी इज नॉट देयर, ही इज ओनली क्लेमिंग थ्रू हर ए मेल हियर, देन there could be testamentary succession, there could be intestate succession. ये हम एग्जांपल के तौर पर समझाने वाले आगे चल के, इसलिए सब बात क्लियर हो जाएगी. The daughter also did not have a right to seek partition. डॉटर को पार्टीशन का राइट ये 2005 तक नहीं था. That means daughters had a share in certain circumstances, but daughter को पार्टीशन सीख करने का कोई अधिकार नहीं था. पर अगर पार्टीशन हो तो शायद उनको हिस्सा मिल जाए. That is possible. Whether it is testate succession और इंटेस्टेड सक्सेशन, ये आगे चल के एग्जांपल के तौर पर मैं अभी समझाने वाला हूं. प्लीज लेट अस गो फर्दर. नाउ पोस्ट 2005 के बाद क्या हुआ, वो 2005 में सेक्शन 6 को बदल दिया गया. सेक्शन 6(1)(6) इज रिप्लेस्ड. इट सेज इन ए हिंदू जॉइंट फैमिली गवर्न्ड बाय मिताक्षरा लॉ, द डॉटर्स बाय बर्थ शैल बिकम ए को-पार्टनर इन हर ओन राइट इन द सेम मैनर एज ए सन. तो उन्होंने कहा कि जो भी डॉटर जिनकी बर्थ होगी, दे विल बिकम ए को-पार्टनर इन हर ओन राइट. शी वुड हैव द सेम राइट इन को-पार्टनर प्रॉपर्टी एज दैट ऑफ ए सन. शी शैल बी सब्जेक्ट टू सेम लायबिलिटीज इन रिस्पेक्ट ऑफ सेट को-पार्टनर एज दैट ऑफ ए सन. तो सब चीजों में लड़के और लड़कियों को एचयूएफ प्रॉपर्टी में बराबर कर दिया गया सन 2005 में. Any disposition or alienation, including any partition or testamentary disposition property which had taken place before 20th day of December 2004, मतलब ये कानून जो आया 2005 का, इसकी एप्लीकेशन है 20 दिसंबर 2004 से. उन्होंने कहा ये जो कानून है ये 20 दिसंबर 2004 से पहले मान लिया कोई डेथ हुई और उसके बाद वो प्रॉपर्टी उस हिसाब से जिसके पास जानी थी जा चुकी, इसका मतलब डिस्पोज हो चुकी या एलिनेट हो चुकी, उसको ये फर्क नहीं पड़ेगा, उससे इसमें चेंज नहीं आएगा. Please appreciate what I am saying. But as soon as there is a death taking place after 20th day of December 2004, then what will happen as a result of that death, that we will see what is going to happen. That will happen only in terms of the new law. एक तो 2005 के बियॉन्ड जो है वो लड़कियों को पूरा हक हो गया, लेकिन अगर 2005 से पहले मान लिया फादर की डेथ हो गई और लड़की को कुछ नहीं मिला तो नहीं मिला, भाइयों में बढ़ गया, वो रीडू नहीं होगा. ये कानून में साफ साफ लिखा है कि कोई भी 20 दिसंबर 2004 से पहले अगर भाइयों ने आपस में बांट लिया बहन को कुछ नहीं दिया क्योंकि पहले कानून में एचयूएफ प्रॉपर्टी में था ही नहीं, तो फिर बहनें बाद में क्लेम नहीं कर सकती। इज दैट क्लियर सर? वी गो फर्दर। कोई कुछ पूछना चाहेगा तो पूछ सकते हैं कहीं भी किसी स्टेज पे, पर आखिर में पूछेंगे। जैसा हमारा नियम है, आप अपने प्रश्न नोट करते चलिए। विल आंसर ऑल योर क्वेश्चंस। बट मेरे को ऐसा लगता है जब हम कंप्लीट करेंगे इस पार्ट को, ये बड़ा कॉम्प्लेक्स पीस है, तो एकदम क्लैरिटी हो जाएगी। As per section 6(2), any property to which a female Hindu becomes entitled by virtue of section 1 shall be held by her with the incidence of co-pastoral ownership and could be disposed of by her by testamentary disposition. देखिए बहुत बड़ी बात इन्होंने कही कि अगर आप एक फीमेल हिंदू हैं और कोई प्रॉपर्टी है जिस पर आपका हक है, सेक्शन 6(1) जो मैंने भी पढ़ा उसके अनुसार, तो आप एज ए फीमेल अपनी जो प्रॉपर्टी, आपका जो हक है उसमें प्रॉपर्टी में, उसको आप टेस्टामेंटरी डिस्पोजिशन से डिस्पोज ऑफ कर सकती है। इसका मतलब क्या हुआ? इसका मतलब यह है कि अगर आपकी मान ली एचयूएफ में 100 करोड़ रुपए की एसेट है और आप में उसका 25 करोड़ का 25% का हिस्सा एक फीमेल के, एक डॉटर है फैमिली की, उसके हिस्से में 1/4 आता है। फॉर एग्जाम्पल देयर आर 3 ब्रदर्स एंड 1 सिस्टर, तो 1/4 उसके जिम्मे आ रहा है। फॉर एग्जाम्पल, एक एग्जाम्पल ले रहे हैं, ज्यादा कॉम्प्लिकेट नहीं करते हैं इसको। So in that case, this 25%, she is alive, it is part of the HUF property, but what she can always write a will, testamentary disposition कर सकती हैं कि जो 25% मेरे जिम्मे का है किसके पास जाएगा। किस हिस्से का कर सकते हैं? सिर्फ अपने हिस्से का। अब ये उनका अपना हिस्सा 25% में कितना है उसको भी हम आगे जाके समझेंगे अभी, क्योंकि उसमें जो उसके नीचे के सक्सेसर है उनका भी हिस्सा हो सकता है, लेकिन she can dispose of her own share by testamentary disposition. Section 6(3) explain when a Hindu dies after commencement of the Hindu Succession Act 2005, his interest in the property of a joint Hindu family governed by Mitaksharal law shall devolve by testamentary or intestate succession as the case may be under this act and not by survivorship. And एक मिनट बेटा आगे चलेगा, please go back. हाँ, and the co-pastoral property shall be deemed to have been divided as a partition had taken place. ये देखिए सेक्शन 6(3) जो है इस कानून का बड़ा इंपॉर्टेंट हिस्सा है, जो लास्ट पार्ट है अभी हमने देखा। इसमें क्या है कि देयर इज ए नोशनल डिवीजन ऑफ द HUF प्रॉपर्टी एट द टाइम ऑफ एवरी डेथ। Suppose Mr. A dies, then in the HUF property it will be calculated that as on date of his death, just immediately before his death, suppose there would have been a partition, then how much share would have gone to whom? And accordingly, the properties are divided. और जो मिस्टर ए जिनकी डेथ हुई है वो चाहें तो अपना चाहे वो डिवोट करें टेस्टामेंटरी सक्सेशन से या इंटेस्टेट सक्सेशन से। दो ही रास्ते हैं, सर्वाइवरशिप का रास्ता नहीं है। सर्वाइवरशिप का रास्ता बंद हो गया, खत्म हो गया। उन्होंने कहा दो ही रास्ते हैं। सर्वाइवरशिप का रास्ता क्या था कि जो बच गए सारा माल उनका, ऐसा नहीं। उन्होंने कहा सपोज मिस्टर ए इज ए मेल, उनकी अगर डेथ हुई है तो उनका जो हिस्सा है वो किस किस में बट सकता है। एक तो वो विल कर जाए तो हिस्सा उनका विल के हिसाब से चला जाएगा, दैट इज कॉल्ड टेस्टामेंटरी सक्सेशन। इवन इफ इट इज HUF पार्ट, बट ही कैन ऑलवेज टेक ए विल। अगर वो विल नहीं करेंगे तो जो नॉर्मल अभी हिंदू सक्सेशन लॉ अभी हमें समझाने वाली अनन्या जी, जिसके हिसाब से कितना हिस्सा किसके पास जाता है, दैट इज कॉल्ड इंटेस्टेट सक्सेशन एज पर हिंदू सक्सेशन लॉ, तो फिर उसके हिसाब से बढ़ जाएगा। ये बात समझनी बहुत जरूरी है। देखिए कि अगर देयर इज ए नोशनल पार्टीशन, आगे समझाएंगे आगे चल के, लेट अस गो फर्दर। अनन्या यू गो थ्रू दिस, जरा समझाइए, फिर आई थिंक आई विल कम इन।
So, notional partition, the concept is after 2005, the daughter will be allotted the same share as her son. So, for instance, that if in a household there's a father, daughter, and a son, and if the father is deceased, then the daughter and the son will get one half each. For instance, if that the son or the daughter, the example which I've given, one of them is deceased, then in that case, their surviving child will get their share and simultaneously will continue. So, for instance, that if for a simpler example, my children will get my share. However, if one of my children is not alive at the time of my death, then that will be passed on to their surviving child, and so on. Now, the interest of sorry, that the interest of a Hindu mitakshar upasana shall be deemed to be the share in the property that would have been allotted to him, assuming that if a partition of the property would have happened. So, as per the entire concept, is assumed that if, for instance, whenever the individual has died, it's considered that the partition for that person's property has taken just before that. That's the whole concept of notional partition. After the commencement of the Amendment Act, obviously, there's no obligation on the son, grandson, or great grandson for the recovery of any debt due from his father solely on the ground. So, Hindu law has a concept known as pious obligation, which was there previously, wherein an individual, whether the son or a grandson, will be having the debt of their predecessor. But there, after 2005 Amendment Act, it's not required anymore. Nothing contained in this section will applies to any partition which has taken place before 20 December 2004, as Sir has already explained earlier. So, as we've already spoken right now, what are the rules of succession? Rules of succession for a Hindu male and a Hindu female are entirely different. So, the rule for class 1 is, in case of Hindu female, are equal rights, which I'll explain to you further. And rule for class 2 is are rights in sequence. So, now the main question that arises is, what are class 1 is and what are class 2 is? So for a Hindu male, the class 1 heirs they have equal rights to the assets. So now what includes your class 1 heirs, which is your mother, spouse, and children. And if any child has died, then their children or their spouse will have an equal, and their spouse will have an equal share. Assuming the mother, spouse, and children, all three are not alive at the time of the death, then in that case, we come to class 2 heirs, which is the father, sibling, living children's grandchildren, or siblings' children. Even assuming that they are not there, so then we have the agnates, which Sir has already explained earlier, but again, I'll just say distant blood relatives of them from the father's side, they can make a claim. And in case even they are not alive at the time of the death, then in that case, the mother side, the cognates, can make a claim. Now, what are your key class 1 as we already discussed? It's your son, daughter, that's the children, the widow, which is the wife or the husband, the mother, son, daughter of the predeceased son, that is in case the children are not there, and widow of predeceased son, and vice versa. So it's basically the first three, like I said, the children, spouse, and the mother. And in case those they are not there, then their successors.
But it is very beautifully can be seen. Please go back to this. You see, in class 1 here, father is not there, nor the husband is there. Because husband, of course, is why he is not there? Because husband will be dealt with when we are discussing what are the succession thing for the females. Right now we are discussing succession of males. Succession of males and females have been differently defined. तो देखिए इसमें मेल में आप देखिए son and daughter are entitled, widow is entitled, mother is entitled, but father is not entitled. A male member dying, nothing goes to father. That is how the culture of the entire nation has developed. And sons oblique daughter or of predeceased son, grandchildren, and of course these are also grandchildren, son, daughter of predeceased daughter, widow of predeceased son, and son oblique daughter of predeceased son of a predeceased son. मतलब great grandchildren. तो great grandchildren तक भी जाएगा, लेकिन ये these are all class 1 here. तो इसका मतलब आगे खैर जब हम एक चार्ट दिखाएंगे तो उससे बिल्कुल क्लियर हो जाएगा. Can we go to the next slide now? Yeah.
So, as we discussed, that we have class 1 heirs, and then comes the class 2 heirs in case of Hindu male. So, what constitutes a class 2 heirs? And their claims are in sequence, which means that they don't have equal share in the concerned property. It basically depends on their sequence. So, for instance, if the father is alive, the father gets the entire property, or the son's daughter, son, son's daughter, daughter, brother, sister. Third sequence is daughter, son, son, daughter, son's daughter, daughter's daughter's son, daughter's daughter. And lastly, the last level is brother's son, sister's son, brother's daughter, sister's daughter. So primarily how it works is that in case no class 1 heir is there, if you have to come to class 2 heirs, then the first person who will get the entire property will be the father. If the father is not there, then it's devolved equally between the concerned individuals. If I may move on. So this is just an example of how it functions in the case of a male Hindu who has died without a will in the state. So in this case, we've given an example.
ये थोड़ा पढ़ने दो बेटा, अनन्या, पहले लोगों को पढ़ने दीजिए जरा. Let them read through this. It is a very complex slide, but it is very, very important. और इससे सारी चीज एकदम clear हो जाती है. I think people should read it through for, we'll give you about half a minute, 1 minute. Just glance करिए अच्छे से, ध्यान से देखिए. ये interstate succession जब class 1 here को जा रहा है. They're all class 1 here. तो देखिए इस केस में दिखाया, there is one son, one daughter. Then one more son was there who has died. Mother, of course, is there. Widow of this male Hindu, and predeceased daughter. The daughter is also predeceased. So there are 2 daughters, 2 sons. There is a predeceased son and there is a predeceased daughter. So predeceased daughter का share जैसे 1/6 आया, so it will go to her son and daughter. And then predeceased son, we have seen again, it is going 1/4 of 1/6 to their heirs. But predeceased son also has another predeceased son. That means there is a predeceased grandson. So his share will go to the respective heirs of the predeceased grandson. ये सारी चीज को एक्सप्लेन करने के लिए बताया है. तो ये सब क्लास 1 ईयर है. और जब मैंने बताया कि इनके शेयर में इक्वल बचेगा, तो ये बात इससे क्लियर हो गई कि सबके हाथ में 1/6, 1/6, 1/6 आएगा. जबकि क्लास 2 हेयर में अगर मान लिया क्लास 1 हेयर कोई नहीं है, क्लास 2 हेयर में अगर फादर है, तो फादर अगर है तो फिर बाकी किसी का मतलब ही कुछ नहीं है. Then everything will go to him. It will not go to rest. Because that is in sequence. Sequence मतलब सबसे पहले वाले को मिल गया अगर है तो, उसके बाद दूसरा, उसके बाद तीसरा, उसके बाद चौथा. वो सीक्वेंस में मिलता है. वो सीक्वेंस इन्होंने समझाई है अभी अनन्या जी ने. अनन्या, we can go to the next please.
Yes, sir. Now, the next thing which we have to consider is that we already discussed about the Hindu male. Now, however, when it comes to the scenario of a Hindu female who has the first claim, second claim, third claim. So, in case of a Hindu female, the first claim is with the son and daughters and the husband. Thereafter, in case the 3 individuals, three persons which I've mentioned right now are not there, then second claim comes in with respect to the heirs of the husband. Third claim comes to the mother and father of the Hindu female. And fourth claim comes to the heirs of the father. And fifth claim comes with respect to the heirs of the mother. So to simplify it and explain it, I'll just show you the chart. I'm sorry, right. So for instance, that if a Hindu female dies, the first claim would be with respect to the children and the husband. In the absence of the husband and the children, the claim would fall to the heirs of the husband. In case they are absent as well, the mother and father of the deceased, that is the Hindu female, will make a claim. And in the absence of all of them, the heirs of the father, which is the Hindu female's father, will get the option. And even in the absence of the heirs of the father, the heirs of the Hindu female's mother can make a claim.
इसमें एक बात मैं जरा सप्लीमेंट करना चाहूंगा बेटा. आई वांट टू सप्लीमेंट वन थिंग. एक बात बड़ी इंपॉर्टेंट है जो फीमेल्स के केस में स्पेशली लॉ ने प्रोवाइड की है कि इन केस सपोज देयर इज ए बिफोर द डेथ ऑफ दिस फीमेल देयर इज ए सक्सेशन, अर्लियर सक्सेशन फ्रॉम हर फादर्स एंड मदर्स साइड. देन and she has got some share out of the share of father and mother. अगर मान लिया जैसे उसको अपनी माँ से या पिताजी से कुछ मिला शेयर, based on her share she got any share. Suppose then she dies and then nothing can go to her husband's side. It can go to her children, but ना तो husband के पास कुछ जा सकता, ना husband के heirs के पास कुछ जा सकता. देखिए, हालांकि हम कह रहे हैं कि वो उसकी डेथ होगी तो सन एंड डॉटर और हस्बैंड को मिलेगा, लेकिन अगर उसकी प्रॉपर्टी में कुछ ऐसा पार्ट है which she has actually inherited either through tested intestate succession or through tested succession from her mother's side or father's side, then it will not go to the husband side at all. That provision is specifically there. Similarly, there is another provision. Suppose there is a female, she gets something out of succession from the husband side, then on her death nothing will go to her father or mother side from that particular portion. That kind of a care the law has actually already taken. We go to the next. Nana ji le lo aage chalo.
So we've already explained this to you in detail in the previous slides. So I'll just briefly explain again. The first rights are with the son, daughters, and the husband. Second rights are with the heirs of the husband. Thirdly would be the mother and father. Fourthly, the heirs of the father. And lastly, the heirs of the mother. Now, when we're talking about the succession planning...
I have explained this beta. I have already explained.
Okay.
This is the inheritance from, this chart समझाइए आप लोगों को.
Right. So, as we showed you a chart earlier for the Hindu male in the state, there's a similar chart for the Hindu female. So, if you could see the first right in the death of a Hindu female in the state would be with the son, husband, and daughter. And in case there's a daughter who's already predeceased or a son who's predeceased, then their share will be divided equally with their children. However, if there's none of these first claimants who are there, the second right would go to the heir of the husband. Now, as Sir has already mentioned, if the Hindu female has inherited any property from a husband or father-in-law, and there's no one to claim in the first right, that's the first claimants, it will directly devolve to the heirs of the husband. Any property which will be devolving to the heirs of the husband will be divided as per the Hindu male succession law. In case even the second claimants are not there, then we go to the third claimants, which will be the mother and father of the Hindu female. Assuming the third claimants are also not there, then we go to the fourth claimants, which will be the heirs of the father of the deceased Hindu female. So, if the deceased Hindu female has inherited any property, as we already mentioned, from her mother, father, then none of the first claimants will have any right to it, and it will directly devolve to the heirs of her father. And any property which will be devolving to the heirs of her father will be divided as per the Hindu male succession law. Lastly, fifth claimants would be, assuming none of the four claimants are there, then it will be the heirs of the mother, and it will be devolved in the same manner as we are discussing at this point. Next slide.
केस लॉ था, जरा केस लॉ.
पहले ये
ठीक है, करिए.
Right. So, when we're talking about a property of a Hindu female, it's considered as per the Hindu succession law to be her absolute property, which means that any property which is possessed by a Hindu female, irrespective of whether it's acquired before or after the commencement of this act, it will be considered to be that she will have full ownership of it and not a limited ownership. So when we talk about the term property means movable and immovable property as well. And nothing contained in this particular, what I've explained to you right now, will apply to any property which is acquired by way of gift or under will or any other instrument. So, in a sense, this is talking about the property which is a self-acquired property and not a property which is inherited by way of will or through a gift deed or any other or maintenance or any of aspects of like that. So over here we're discussing few case laws where we're talking about the property of a Hindu female, which is her absolute property right. So for instance, we have the 2006 judgment of Supreme Court in the case of Sadhu Singh versus Gurudwara Sahib Narike, wherein the apex court has essentially held that the essential ingredients of applicability of section 14 are antecedents of the property, possession of the property by a female Hindu on the date of the commencement of the act, and existence of right in her over it. Mere possession of property is not enough, and nature of right acquired is important. Subsection 1 of Section 14 applies where a female Hindu is possessed of the property on the day of the act in which she had a pre existing right, even if the right be to a limited estate or a right to maintenance. In the case of Santosh versus Saraswati Bhai, the apex court has held that Section 14.2 is confined to cases where property is acquired by a female Hindu for the first time as a grant without any pre-existing right under a gift, will, instrument, decree, order, or award, the terms of which prescribe a restricted estate in the property. When the property is acquired by a Hindu female in lieu of her right to maintenance, inter alia is in virtue of a pre-existing right, and such an acquisition would not be within the scope and ambit of Section 14.2. Even the instrument, decree, or award allotting the property to her prescribes a restricted estate in their name. Right. Akhilesh, would you want to continue from there?
Thank you, Ananya. See, we already don't have that much of time, but the concern is whatever shall be the opening lines. Now I have got the chance to speak at just end of the seminar because we already have such a senior learned person on the show. So, see, the thing is succession, the word succession. See, rather than going into the law, first thing I want to tell you that in India, especially in India, there are, lots of myths which are actually people perceive in lots of majority of people. See, the first thing whenever we talk about succession planning, the first thing in the first slide in every presentation is why succession planning. So I don't think there is any need for this question, why succession planning, because of death. Just because death is there, that means the succession planning should be there. So the answer for the why succession planning is the answer is death. Because you will die, that's the only reason you have succession planning. The second myth which people generally have in their minds is, and lots of people have the question in their brain, like the succession planning is done something like a static thing. You have to just do it only for a once. It's not like that. Succession planning is not a static thing. It should be a dynamic and it should be an ongoing process. It's not like we have to just make a will, we have to just make a trust and the things will go absolutely right forever. It's not like that because nothing is, permanent. So in terms of these things, we can very clearly deduce that the succession planning is nothing static and it shall be made considering each and every factor and it should be dynamic and not in a static form. Another myth which generally people at large in India should have is like the succession is only for the rich peoples. This, in my very short tenure and very short experience, I feel that generally whosoever else our client are, generally they are the rich people. And I haven't met any, people who are poor or something like that, who actually come for us for any succession planning and all. Because this the misconception generally in India prevails like that succession planning wills, these are the concept only made for the rich people. So as we are professional, we are duty bound to make awareness in the our fraternity that it not be like that, that succession planning is only for the rich people and not for the poor. And I think fourth thing is which feel that people generally take succession planning as a cost. Rather, it's an unnecessary cost for them. But I don't know why they think like that because if we practically think, whatever we have earned in our whole life, from starting till end, whatever we have earned till today, and for that planning, how can we even think of that it is an unnecessary cost? Whole life we have spent earning, and today we are standing at a place where we have to think about how to manage this thing, and where if we have to spend some amount that never ever be any unnecessary cost. So that's all from my side. I will let the podium to Ananya.
So, as we already discussed right now, what are the mode of succession? So, for instance, that if there are two or more heirs who succeed together to property of an interstate, they shall take property in the two manners. One, if as it's allowed in the Act, otherwise per capita and not per stripes, and tenants in common and not as joint tenants. Another very interesting concept is right of a child in womb. A child who's in the womb at the time of death of the intestate, that is deceased, and who is subsequently born alive, shall have the same right to inherit to the intestate as if he or she had been born before the death of the intestate, which primarily means that just before the death, it's assumed that if there's a child in the womb at that point, it's assumed that just before the death of the concerned individual, the child was already born. So that child who's in the womb at that time has the same rights as that of the other individuals. Again, the same time, another common aspects of law is that a person should not benefit from their wrongdoings. Similarly, a person who commits murder or with the commission of a murder will be disqualified from inheriting the property of the person murdered. So, for instance, that if an individual has murdered their immediate seniors to get the concerned property or inherit it, that case they will not be entitled to the same as per Section 25 of Hindu Succession Act. Also, in case that if there is no individual alive or present at the time of the death of the deceased, then in that case, the entire property devolves to the government. Also, every Hindu person has the right to dispose of their property by way of will or any other disposition which they deem suitable. Another important thing which we have to really consider is what is the difference between an ancestral property and self-acquired property, because these are two terms we hear a lot. First of all, ancestral property as per the Hindu law is known as Kopasni property, which you already discussed. And after 2005 amendment, a girl who is born into a joint Hindu family is allowed to take an equal share in the ancestral property. However, self acquired property is the property which is purchased by a person from his own money, or any property he acquired as a share of the division of any ancestral co-pasni property. So it is very important to note that, for instance, if an individual has inherited any ancestral property and that ancestral property has been divided or sold, so the amount or the money which the person has received from that the sale of the ancestral property, if that's used to purchase another property, that's considered as a self-acquired property of the concerned individual. So we've listed down a few case laws on what constitutes as the ancestral property. And in this case, I would like to, for simpler terms, to bring your attention to the case of Mr. Mangamal versus T.B. Raju from Supreme Court, wherein the court has held that any property inherited up to 4 generations of male lineage, which means father, father's father, which is grandfather, father's father's father, great grandfather, and uh, great grandfather, which is termed as ancestral property. In other words, property inherited from mother, grandmother, uncle, even brother will not be considered as ancestral property. Ancestral property is considered the right of property which accrues to the co-partner on birth. Now, what is self-acquired property? Self-acquired property is primarily as long as the property remains in the hand of a single person. It's considered to be treated as a separate property. Basically, that if I have bought the properties with my own amount, it's considered as self-acquired property. I've already discussed it. Sir, would you like to explain this?
बेटा इससे पुराना yeah. You see, it is important for us to actually distinguish what is a self-acquired property and what is a inherited property. And this law has undergone a big change recently. You see, in this particular case of Govind Bhai, Chotu Bhai versus Patel Raman Bhai, the Honorable Supreme Court was dealing. This is, of course, a judgment of 2019. एक बार जरा शुरू से शुरू करेंगे, थोड़ा सा जहां केस लॉ शुरू हुए थे उन्होंने एक बार, हाँ देखिए 2006 का केस है, वो 1983 का केस है. एक मिनट पीछे जाओ बेटा. Yeah, that's right. You see, we start from Deepa versus Vasant Singh, which is a 1983 judgment. Obviously, this is before the 2005 amendment. this 2018 case of Maganmal versus TB Raju, which also just now Ananya has actually explained to all of us, this is also actually explaining what is ancestral property with in the light of Hindu Succession Act as it was existing for so many time. They're only explaining. So this is just to explain what is ancestral property, and this is no bearing on the today's law of how it will devolve, because it has this whole process. The Honorable Supreme Court, as we go further, we'll see, has actually modified very significantly in view of the 2005 amendment, and one after another case laws have been coming. We go to the next, please. Now, in this Sheila Devi versus Lalchand, they are talking of self acquired property. देखिए मोटी मोटी बात यह कि सेल्फ एक्वायर्ड प्रॉपर्टी वही प्रॉपर्टी थी अभी तक की जो सोच थी, सेल्फ एक्वायर्ड प्रॉपर्टी में सिर्फ वही प्रॉपर्टी आती है, द प्रॉपर्टी विच यू अर्न आउट ऑफ योर ओन एफर्ट्स. आपने अपना पैसा लगा के बिजनेस शुरू किया, उस पैसे से जो आपने कमाया, दैट इज सेल्फ एक्वायर्ड प्रॉपर्टी. अगर आपने पुश्तैनी पैसे से कोई बिजनेस शुरू किया और पुश्तैनी पैसे में वो जो सबके कॉमन हौच पौच में, इट विल बी कंसिडर्ड एज, if not as self-acquired property, it will be possibly a family property. I think that was broadly understood. But now as we are going further, the things are becoming finer and finer, because number one, undivided families are becoming few. The size of the family is also coming down, and the law is also undergoing a change. So long as the property remain in the hand of a single person, this is a 2006 judgment. Please appreciate. This is not based on the 2005 prospective law. क्योंकि जो जजमेंट सुप्रीम कोर्ट में 2006 में पहुंचा है, that cannot relate to a post 2005 death. Please appreciate this. So long as property remains in the hand of a single person, the same is to be treated as separate property, and the such person will be entitled to dispose of the co-pastoral property as the same were his separate property. But if son is subsequently born to him or adopted by him, the alienation, whether it by way of a sale, mortgage, or will nevertheless stand, for a son cannot object to alienation so made by the father. देखिए एक बेसिक बात जो इतने साल से लगभग for last 45 years I have been a student of law, so that is what we have really seen is that normally HUF property also, the karta of the family have full right to dispose of the property in manner in which you want. That is what is called karta. So long as he is not disposing it off in a manner that goes against the family interest. Suppose the father of the family wants to dispose of the family property to another woman which is outside the family, or he wants to spend on in a casino or in horse races and the things like, then obviously, even if it is a combined property, any member of the family has a right to object. What we said, that female had no right even earlier to ask for a division, but those very females being a member of the family, like now the mother which has come after marriage to the family, she is a member of the family. She is still not a co-partner, because only daughters and sons are co-partners. मैंने आपको शुरू में मैं कह ही रहा था आपको कि जो शादी होकर लड़की दूसरे परिवार में आती है, उसके लिए कुछ अभी इस लॉ ने नहीं देखा है, क्योंकि उस परिवार में उसके पास कोई हक नहीं है किसी तरह का पार्टीशन मांगने का, कुछ कहने का, पर एक हक जरूर है उसे अपनी मेंटेनेंस का. तो अगर उस फैमिली का कर्ता अगर पैसे को उड़ाता है, गलत तरह से इस्तेमाल करता है, then she can always go to the court and tell my lord, and the my lord will give a stay in her favor that this man is actually alienating the property, is transferring, misusing the property, is diverting the property of the family, which is against the interest of the family. So ये एक फैमिली प्रॉपर्टी है सेल्फ एक्वायर्ड, पर अगर उसकी कुछ सेल्फ एक्वायर्ड प्रॉपर्टी है, वो चाहे कुछ भी करे, nobody can really stop them. We go to the next please. I think खत्म होने वाले अपना टाइम 5:49 हो गया. फिर भी ये वाला पार्ट कंप्लीट करते हैं. It was held that the Mitakshara father has absolute right of disposition over his self-acquired property, to which no exception can be taken by the male descendant. And it was, again, this is also 2019 law. It was held that it was not possible to hold that such property bequeathed or gifted to a son must necessarily rank as a ancestral property. ये बड़ी important change आई है. It was further held that a property gifted by a father to his son could not become ancestral property in the hands of the donee simply by reason of the fact that the donee got it from the father or ancestor. देखिए पहला वाला जो कानून था वो डिफरेंट था, but I think this Supreme Court judgment, what it is saying, Suppose out of the family property, family asset, the father, the karta of the family decide, okay beta, आपको मैं 50 लाख रुपए दे रहा हूँ, you आप ये business शुरू करो, they are hereafter belong to your family, will have nothing to do. And suppose he executed on behalf of the family, execute a gift deed in favor of the son, then that property will remain absolutely the absolute property of the son. It will be self-acquired property. It was held that it was not possible to hold that such property bequeathed or gifted to a son must necessarily rank as ancestral property. चाहे वो 50 लाख रुपए हैं, चाहे कोई मान ली एक दुकान उसको दे दी, बेटा तेरे को गिफ्ट कर दी फैमिली से, अब तू जाने, तेरा काम जाने, you manage it independently, this is yours. That hak is always there with in a joint Hindu family. Please appreciate this. When we are talking of succession, it is based on death के बाद क्या succession होगा, लेकिन जब तक फैमिली, जॉइंट फैमिली प्रॉपर्टी है, उसको किसी को भी देना, मान ले लड़की की शादी है कोई, उस लड़की की शादी में उन्होंने कहा मैं 3 करोड़ रुपए इसमें से फैमिली से खर्च करने वाला हूँ फैमिली की शादी में, तो दैट करता ऑलवेज हैव राइट, नोबडी कैन ऑब्जेक्ट इट. प्लीज अप्रिशिएट दिस. नो फैमिली मेंबर कैन ऑब्जेक्ट इट. ऑफ कोर्स ये हो सकता है अगर एक भाई की लड़की की शादी में आपने 3 करोड़ खर्च किया है, तो दूसरा भाई भी ये डिमांड कर सकता है भाई मेरी बेटी की शादी में भी आपको कम से कम इतना एलोकेशन तो करना ही चाहिए, बट वो डिमांड कर सकता है. इट कैन बी अ डिमांड, इट कैन नॉट बी अ राइट. लेट अस गो टू द नेक्स्ट. अभी देखिए एचयूएफ प्रॉपर्टी, ये 1986 का जजमेंट है. ये जजमेंट्स की डेट जरूर ध्यान से देखिए, क्योंकि इससे हम पुराना और नया दोनों को मिश्रण को समझाने का प्रयास कर रहे हैं. It says when the son inherited the property in the situation contemplated by section 8, it does not take it as a karta of his own undivided family, but take it in his individual capacity. ये 1956 के बाद भी कानून चेंज हो गया था. The property which is devolved upon the father of the respondent in the distant case on the demise of his grandfather could not be said to be HUF property. तो बिल्कुल सही कहा था गर्ग साहब ने कि ऑटोमेटिकली प्रॉपर्टी HUF नहीं बन जाती. जस्ट बिकॉज इट इज inherited property does not become HUF property. For that some positive action has to be taken. Suppose the father is dying and he says, okay, on my death, out of my property, out of our ancestral property, such and such property will go to such and such son, and he actually वो अपनी will एक तरीके से लिख जाते हैं. That is called testamentary disposition of ancestral property, and which the man who is dying, he is giving it out of his own share. So that will be received by the person not as ancestral property, not as HUF property, but as a self-acquired property. But suppose father while giving it says, ये मैं मिस्टर ए मेरा बेटा उसको दे रहा हूँ, उसको और उसकी फैमिली के लिए दे रहा हूँ मैं, तो then it will become a HUF property as far as him and his family is concerned. So मिस्टर ए की HUF की प्रॉपर्टी बन जाएगी वो. So it depends on what you are saying, what you are doing, उसी के हिसाब से तय होगा. तो आपका जो डॉक्यूमेंट है वो क्या कह रहा है, उसे बहुत एज चार्टर्ड अकाउंटेंट और एज ए लॉयर हमें बहुत ध्यान से उसे बनाना है, क्योंकि मैंने शुरू में बताया था कि आदमी क्या चाहता है, कौन सी चीज किसके पास जाए, किसका क्या क्या हक रहे, किसका क्या क्या हक ना रहे, वो ठीक से डिफाइन होना जरूरी है. इसलिए इन बारीकियों को समझना हमें जरूरी है. गो टू द नेक्स्ट प्लीज. डॉक्टर साहब खत्म कर रहे हैं बस. आई थिंक वी विल क्लोज इन 1 or 2 minutes. कितने केस लॉ रह गए देखिए, एक मिनट जरा अनन्या देखिए प्लीज, कितने केस लॉ रह गए. काफी है अभी, काफी हो सकते हैं. वी कैन नॉट कंक्लूड देम. वी हैव टू पोस्टपोन इट टू द नेक्स्ट.
सर लेट अस पोस्टपोन इट सर.
हाँ, क्योंकि जल्दी में करेंगे तो बात रह जाएगी बीच में, बात बीच में रह जाएगी सर, जल्दी में.
अच्छा चलो कर लीजिए सर, प्लीज कर लीजिए.
नहीं कर नहीं रहे, अगली बार ही करेंगे, क्योंकि इसमें कम से कम 15-20 मिनट लग जाएंगे.
ठीक है, आप क्वेश्चन ले लेते हैं सर फिर.
हाँ, क्वेश्चन ले लीजिए.
So we have question from Gaurav Kesaria. He is asking, property held in private trust is now dissolved and property is transferred to the beneficiary. Whether any capital gain arise on such transfer?
Whether a capital gain will arise on the transfer to the beneficiary. First of all, this is not a transfer. In my humble submission, when the property devolves onto the beneficiary, it is not a transfer. The transfer has taken place only when the settler has settled the property to the trust. At that time, of course, there was a transfer. That is why at that time we test under section 56(2)(10) of the Income Tax Act as to whether it is taxable or not. So that can happen only when, in case the people who are beneficiaries, they are all who are close relatives as defined under section 56(2)(10) के पर्पस के लिए जो भी रिलेटिव है, अगर वही सिर्फ मेरे उसके बेनिफिशियरी हैं, then it is not considered as a gift or a transfer. But in case in case suppose you create a private trust for unrelated parties, in that case, at that stage itself, it will attract taxation. So what we are trying to say is that once a property is held in a trust, the beneficial ownership is always there with the beneficiary itself. So there is no transfer which really gets involved.
So next question we have, he's asking, I have a self-acquired, self-occupied house property.
Sir,
How to plan for inheritance of such
माविया
property?
एक मिनट.
Yes.
जैन साहब, मैं इसमें एक चीज और पूछना चाह रहा था कि अगर अनरिलेटेड पार्टी के लिए भी प्राइवेट ट्रस्ट आपने बना दी और अगर इरिवोकेबल है तो 47 में तब भी वो ट्रांसफर नहीं माना जाएगा. अगर होगा तो 56(2)(10) में टैक्स लगेगा बेनिफिशियरी के ऊपर सर. इफ आई एम नॉट रॉन्ग.
56(2)(10) में टैक्स लगेगा.
बेनिफिशियरी पे लगेगा सर.
रिसीवर के पास भी लगेगा, गिवर के पास भी लगेगा दूसरे सेक्शन में.
सर पर 47 में क्या वो ट्रांसफर माना जाएगा सर? इरिवोकेबल ट्रांसफर है तो प्राइवेट ट्रस्ट के लिए.
देखिए, मैंने बताया कि आज का सेशन को अगर हम टैक्सेशन डिस्कस करेंगे तो मुश्किल हो जाएगा.
अच्छा ठीक है सर, प्लीज कंटिन्यू सर.
क्योंकि टैक्सेशन की बारीकियां काफी गहराई से जाना पड़ेगा. फिर आप कहेंगे एक सेशन पूरा हम टैक्सेशन पे रख देंगे.
बिल्कुल अच्छी बात है.
क्या है कि टैक्सेशन में इतनी मलाई है, इतना इंटरेस्टिंग सब्जेक्ट है, फिर लोग सक्सेशन का भूल के टैक्सेशन में लग जाएंगे.
ठीक है सर, प्लीज सर. नेक्स्ट क्वेश्चन.
हाँ जी, हमारे मित्र हैं महावला एंड कंपनी से. सब पूछिए. आई हैव ए सेल्फ एक्वायर्ड, सेल्फ ऑक्युपाइड हाउस प्रॉपर्टी. हाउ टू प्लान फॉर इनहेरिटेंस ऑफ सच प्रॉपर्टी. देखिए, इसके लिए तो सबसे सही है कि आई ऑफ कोर्स, वैसे मैं आपको बरसों से जानता हूं, आपकी तस्वीर देख के आपको पहचान रहा हूं, बहुत पुराने मित्र हैं. लेकिन सवाल ये है कि आई डू नॉट रिमेंबर योर फैमिली कॉन्स्टिट्यूशन, बट इन एनी केस you have to see not only self occupied self property and self acquired property. You have full right. आप चाहे उसकी विल करें, चाहे उसे इंटरेस्टेड टैक्सेशन में इंटरेस्टेड में छोड़ें. इंटरेस्टेड छोड़ेंगे तो आपकी वाइफ के पास आपके जाने के बाद और आपके बच्चों के पास जाएगा. आप चाहते हैं नहीं, अपने को मेरे को अपने किस किस को और लुक आफ्टर करना है इसी सेल्फ ऑक्युपाइड हाउस से, और किस किस का रहने का हक जरूर होना चाहिए. सपोज योर मदर एंड फादर आर लिविंग विद यू एंड यू डोंट वांट देम टू बी चेक्ड आउट ऑफ द हाउस आफ्टर यू हैव गॉन. योर वाइफ and your children don't ask them to say, sir, thank you very much, your son is no more here. आपका तो कोई हक नहीं है, आप नमस्ते करो, आप जाओ यहाँ से. अगर आप ऐसा नहीं चाहते हैं तो then definitely you need to definitely plan it properly. All the mother का हक तो रहेगा, father का कोई हक नहीं रहेगा उसके बाद after the date of the death. तो इसलिए properly will करना मेरे हिसाब से बहुत जरूरी है. और खाली एक हाउस को मत देखें. We have to see various properties and do the balancing. एक एक आदमी देखें, जैसा हमने शुरू में बताया कि लिस्ट करें अपनी सारी प्रॉपर्टीज की, एसेट्स का, लायबिलिटीज का, कौन ईयर्स है, किसकी क्या जरूरत है, पूरा प्रोसेस करिए. इट इज नॉट पिक एंड चूज कि इसको ऐसे कर लिया. इट इज ए ओवरऑल प्लान. सक्सेशन हैज टू बी ओवरऑल प्लान. और आप तो देखिए बहुत पुराने मित्र हैं, हम कभी भी बैठ के प्लान कर सकते हैं. थैंक यू सो मच
सर. आई मे ऐड समथिंग हियर.
हाँ जी, बोलिए
सर. जो द लास्ट क्वेश्चन व्हिच ही एक्चुअली आस्क्ड, सर हैज आस्क्ड, see how to plan is depend upon what you need. If you have the answer of what you need, then it is very easy for you to how to do the inheritance.
बिल्कुल ठीक कहा आपने.
Next question we have from CA SP Goyal ji. He is asking, in case of movable assets, that is cash, bank balance, investment, which is subject to change with the passage of time, how to cover that contingencies in will if written today?
देखिए, इसका तो बड़ा सिंपल आंसर है. हम लोग देखिए, कैश, बैंक बैलेंसेस, इन्वेस्टमेंट, ये तो सब चेंज होंगी, रोज चेंज होंगी, और आपको स्पेसिफिकली डिफाइन नहीं कर सकते. तो आपको हम लोग जो जैसा हम लोग विल्स में ड्राफ्ट करते हैं, अगर हम समझते हैं कि हमारे जितने भी ये मूवेबल एसेट हैं, इनको मान लिया हम चाहते हैं 1/3 3 हिस्सों में बटें, या 30-30-40 बटे, तो ऐसा हम डिसाइड कर लेते हैं. तो इसकी ट्रांसफॉर्मेशन के बाद ऑन द डेट ऑफ डेथ जो भी होगा उसको इवेल्युएट करके किया जा सकता है. और ऐसा भी कर सकते हैं कि हम इन्वेस्टमेंट के लिए अलग नियम बना लें अपनी विल में, बैंक बैलेंस कैश के लिए अलग बना लें, और इमूवेबल प्रॉपर्टीज के लिए अलग अलग बना लें. ऐसा कुछ कर सकते हैं. पूरा हमने अभी रिसेंटली एक केस में, अखिलेश को मालूम है, हमने बहुत अच्छे से इन सब चीज़ों को डिवाइड किया है. इन्वेस्टमेंट अलग डिफाइन किया, बैंक बैलेंसेज अलग डिफाइन किए, प्रॉपर्टी जिनसे रेंट आ रहे हैं उनको अलग डिसाइड किया, सबको अलग अलग किया डिपेंडिंग ऑन व्हाट इज द रिक्वायरमेंट, एज अखिलेश राइटली सेड. Akhilesh, you want to supplement this?
Sir, basically the answer for this question may be the living will backed by a trust is the perfect answer for this thing.
जी.
So next we have asterisk property under section 29 goes to the central government or to the state government?
Central government, please. Government of India.
So Next question we have, he's asking, I have a self-acquired property put under my HUF. Can I will it to one of my child only?
देखिए, अगर आपकी सेल्फ एक्वायर्ड प्रॉपर्टी थी, आपने अगर अपनी एचयूएफ में कंट्रीब्यूट कर दी है, तो वो आपकी प्रॉपर्टी नहीं है। अब आपका उसमें हिस्सा बड़ा लिमिटेड है, तो आप सिर्फ आप अपना हिस्सा विल कर सकते हैं जिसको भी विल करना चाहें। ये अभी हमने समझाया नहीं, अभी हमारा वो नंबर आया नहीं। जब नंबर आएगा, जब हम समझाएंगे कि एचयूएफ में किस तरह से आपका कितना शेयर बैठेगा, आई थिंक दैट पॉसिबली विल हैंडल इन नेक्स्ट वीक। बट इसमें ये प्रॉपर्टी आपकी है ही नहीं। अब आप ये सोच रहे हो आपकी है, आपकी हो सकता है 1/4 हो सकता है, आपकी 1/6 हो। देन डिपेंडिंग ऑन, आप पूरा फैमिली चार्ट दिखाएंगे तो हम कैलकुलेट करके बता सकते हैं कि आपका कितना हक है इसके ऊपर। अब तो हक आपने छोड़ दिया ये एचयूएफ में। आप चाहें सिर्फ अपने बेटे को दे दें, अपनी बेटी को दे दें, आप नहीं दे सकते हैं।
But sir, it can be possible if it dissolve their HUF.
डिसॉल्व करेंगे एचयूएफ तो अखिलेश जी, उस केस में इनको कंप्लीट डिवीजन करना पड़ेगा एचयूएफ का। अगर एचयूएफ डिवॉल्व करेंगे, कंप्लीट डिवीजन होगा तो भी उतने हिस्से होंगे जितने डेथ के बाद होंगे। वो इनका हक ही नहीं है। वो तो मान लिया डॉटर का हिस्सा डॉटर का है, सन का हिस्सा सन का है, इनका हिस्सा इनका है, वाइफ का हिस्सा और बाकी मेंबर्स का हिस्सा बाकी मेंबर्स का है। एक बार एचयूएफ में कंट्रीब्यूट किया, सोच समझ के करना चाहिए ना। इन्होंने मतलब दिस वाज ए रॉन्ग स्टेप फॉर एनीबॉडी टू कंट्रीब्यूट हिज इमूवेबल प्रॉपर्टी, मोर पर्टिकुलरली इन एचयूएफ। हम कभी सजेस्ट नहीं करते कि एचयूएफ में इमूवेबल प्रॉपर्टीज आप डाल दें। इमूवेबल प्रॉपर्टीज को एचयूएफ में डालना, आप समझिए मुसीबत मोल लेना है। This I think we'll explain in detail in the next time also. We go to the next.
Sir, that's all questions we have. Now I request our session moderator Sunil Garg ji to give vote of thanks.
First of all, I thanks our guest speaker Shri Vinod Jain ji and his team for such a beautiful deliberation. And as you know, friends, this topic is very important topic in these days. Everybody has to plan business succession as well as family succession. Thank you, Jain sir. I also thanks our guest of honor today, Sri Amit Agarwal ji, who is past chairman of Mathura branch. Thank you, Amit ji. And friends, now it's a learning process, and I will request all my friends, please put as many questions, or you can send your questions to my WhatsApp number, and that is 9811015509, so that we can forward those questions to Honorable Sri Vinod Jain ji, and he can include those questions also in his deliberation. Thank you once again, everybody, to join this. Thank you, audience. Thank you.
Thank you, sir.
Next Saturday, please, we'll meet at 4 o'clock.
Thank you, sir. Thank you, sir. My pleasure, sir.
नमस्कार
Thank you,
सर,
sir.
नमस्कार सबको।
Namaste.